and its rich cultural heritage. We request everyone to kindly rise for Tamil Thai Valtru. Formally inaugurate the proceedings, it is our honor to invite Ms. Sunita Rai Ma'am, Faculty Coordinator, Moot Court Association, School of Excellence in Law, who has been a constant source of guidance, support, and encouragement to the MCA to deliver the welcome address.
Respected faculty members and my dear students, good morning, everyone. It gives me a great pleasure to welcome you all to the MCA Freshers Orientation 2026. To begin with, I would like to place on record our sincere gratitude in absentia to our Chief Patrons, Justice P. Bharatidasan, Senior Judge, Madras High Court, Convener Committee, Om Prakash Sir, Advocate, Madras High Court, and Tirumadi P. Sumadi Ma'am, Law Secretary, Government of Tamil Nadu, and our patrons, Professor Dr. Gauri Ramesh Ma'am, Registrar, Tamil Nadu Ambedkar Law University, whose continued support and encouragement have played an important role in nurturing the Moot Court Association. I would also like to warmly acknowledge our faculty advisors in absentia, Professor Dr. V. Balaji, Dean, School of Excellence in Law, Tamil Nadu Ambedkar Law University, and Professor Dr. Ranjit Homan Abraham, HOD, Department of Cyberspace Law and Justice, and our student conveners, Ashwat, Monica, and Mariam Ami, for their constant efforts in keeping the mooting culture of our institution active and vibrant. And to all the freshers here today, a very special welcome to all of you. You are beginning an exciting part of this journey, and in this career, mooting is very important, and more particular to say, your seniors, that is the present President Ashwath Dinakaran and Secretary Monica and General Secretary Mariam Mamin, and under the guidance, there are many members too in the Moot Court Association, and they have gained valuable experiences through mooting and attending many Moot Court competitions. So make the best use of it, learn many things from them, and uh, so welcome once again, welcome all of you. Thank you. Happy mood. Thank you.
Thank you, ma'am, for those warm and encouraging words. Every mooter remembers their moot experience, the excitement of your team, the support of your mentors, the intimidating oral rounds, the fiery opponents, the esteemed panel of judges, the sleepless nights, and the last minute research and preparation, and everything that goes into a moot. To introduce us to the world of mooting and what it entails, we have with us Ms. Mariam Amin, General Secretary of the Moot Court Association, to take us through this journey. Mariam, the floor is yours. A very, very good morning, everyone. Like, a very good morning, everyone. I hope all of y'all have not forgotten me from your whole induction. So I will start with a disclaimer. Me and Anne, who also you would remember from the Fresher'S induction, we told all of our colleagues here at the MCA that the Freshers this year are so talented. I remember the whole talent show that all of you guys did and all of you wanted to come and perform. So we've given them, we've hyped you all up so much. So please don't embarrass me and make me look like a fool in front of them. Let's keep this session extremely interactive. Like, this is the best time for you people to ask the most stupidest doubts that you have with regards to mooting, how to moot, what to moot, how to research, any possible thing. Therefore, use it. Don't shy away. And if we're posing questions to you, please answer whatever you know. Okay? Can I take that as a promise from y'all? Yes? That's not good enough, guys. I don't know, but fine. Okay. Right. So what? My name is Mariam Amin. I am the General Secretary of the MCA this year. And I today will be introducing mooting to all of you. So my session is going to be relatively simple, very basics, and the sessions after me will be a little more technical. I hope everyone has your book and pen. Yes? Can I see the books and the pen? Also, everybody in the back, can you see the PPT? Yes? No? Should we switch a light off? Can we please have these few lights switched off? Switch on and I want to see. Okay, okay. Now, people at the back, can you see the PPT? Yes? No? Tell me something, guys. Can you see the PPT? Okay, great. So, before I begin, we have a small activity for you. Throughout the course of judge, appellant, Supreme Court, High Court, so many words everybody will be using throughout the session. So the activity is all of you will take note of 30 such words. So pay very close attention to everything we are saying. You will make note of 30 words and you will also write like a 2-word, like a 1-line meaning of what you think that word is. Like for example, somebody says coat, you will write coat and you'll write like 1 line of what you think a coat is. Okay, the first 15 people that give me 30 words with a 1-line meaning, the meaning need not be correct, just what you think it means. We have a small treat for you. Okay? Everyone got the rules? Yes? I can't hear yes from the back. Yes? Backbenchers are not responding only, but okay. Right, so we will start now with what is a moot. I want 2 people here. Have you heard the word moot before? The ones who say yes, can I have one person stand up? Anyone? Yes. Can you please tell me what your name is? Sashwati. Sashwati, what do you think a moot is? Something like a mock court. You're quite on point. Anybody else has any other answer? Legal arguments. Anything else? Imaginary cases. Yes. Anything else? I heard something here. Trial courts. Yes. Anything else? A simulated court. Yes. So in my PPT, I've written 4 options, right? What is a debate competition, a courtroom simulation, an excuse to travel, and D, all of the above. So if you ask me, how I would define a moot is that a moot is a simulated court proceeding. We've not gone to court yet. We pretend we are in court, and we have all those option C benefits as well that we come across. So the next thing is meet the players. Who are the players in a moot court? Who do you think? 2 student council. Anything else? Judges. Anything else? Witnesses for trial competition. Sorry? Appellate and defendants. Yes. So ideally in a moot court competition, there are 3 players. That is one team, my opposing team, and the bench. The bench is what we call the judges. Even in real courts, the judges that decide on the matter, we call them a bench, a single judge bench, a dual judge bench, a full bench, a constitutional bench. So my team ideally will consist of 3 members, 2 speakers and 1 researcher. The speakers and the researchers will prepare a memorial. They will read the proposition. They'll prepare a whole document of sorts. Later on in another session, we'll go into detail as to what a memorial is and what goes inside it. And after that, when you come to once the memorial is submitted, the researcher will sort of take a back seat and help the speakers refine their script, and the speakers will argue the matter. The opposing counsel will be the counsel that goes against you. So when we go for national moot court competitions or international moot court competitions, there'll always be a team from another university, another country in front of us, and we'll have to argue against them. So if we are the petitioner, that is, if we are the person bringing in the complaint, or we are the ones filing the petition, there'll be somebody responding to it, somebody defending them. Sometimes they might get petitioner, we might get respondent. So very briefly, these are the 3 players that you will see in a moot court competition. Yeah. What do we do in moot? So I have a 7-step thing, a 7-step process that I've noted down. I don't know if you guys can see it very clearly, so I'll read out to you. First is read the proposition. Can anybody tell me what a proposition is? The situation, the case, the facts. Somebody from the back has to tell me. What do you think a proposition is? The exact facts, details of the case. Somebody here? What do you think a proposition is? Sorry? Issues? Yes. So I think all of you all have understood what a proposition is. A proposition is the statement of facts. That is what has happened in a situation. And finally, sometimes the issues will be given for you, that these are the issues before this court. And sometimes you have to read the proposition and understand what issues have arisen. So what a proposition will essentially tell you is, it will tell you what has happened, who is aggrieved, who has gone to court, and all the background details of how this came to be, etc., etc. So what is the first thing we do while mooting? Read the proposition. Correct. Second, after we read the proposition, we are able to identify the issues. Like, for example, if the fact sheet tells us that a journalist was trying to speak and his video was removed off Instagram. Or like, we see this very often where influencers will post screenshots saying that they are Their content was restricted. So if they give us a fact sheet like that, what are the issues we identify? That their freedom of speech, is it curtailed or not? So this is identification of issues. In most propositions, these issues will be provided. Very few you will have to go and find out. The third one is research. Once you know what the issues are, you will research upon it. On research also, we have a whole technical session, so I will not get into the details. It's basically understanding what the law is on that matter, what the courts have previously said on that matter, etc., etc. Fourth one is building your argument. That is, once you have good research, what you're going to do is you're going to frame it according to your facts and circumstances. That is how this case supports me, what my contention should be. You sort of put them all together. Fifth one is drafting your memorial, the written document that you will be preparing. We have another technical session on it, so I won't get into the details. Sixth is practicing. Once you submit your memorial, all that is left is your oral spoken round. So practice in the sense you read your memorial, you see what you've and you argue your case. You try to you try to think what the other counsel will argue and you try to find answers to that, etc., etc. And finally, the best part, according to me, that I usually speak in Moot, which is your oral rounds, where you get to present your arguments, you get to convince a set of judges as to what your issues are. Before we go on to the next slide, I want to tell you guys, please do not feel intimidated by voting. Don't think, oh my God, you have to speak English very fluently if I have to vote. I have to, I have to be so knowledgeable. I have to, I have to be like some Einstein level genius to do voting and to put in my time. Voting is for absolutely everyone. And to share a very short story, when I was in my first year, I still remember one of the questions I asked one of my mentors who was previously in the MCA. So I also, like you guys, was sitting in my Fresher'S orientation, super excited and everything. And then I started preparing my memorial for the Fresher'S Moot. And we put a lot of tables in our memorials. We put table of contents. We put table of all the abbreviations we've used. And I did not know how to add a table in MS Word. So one of the questions I asked my mentor at the time was, Anna, how do I add a table in MS Word? It's not even a legal question, something so simple. Therefore, if you guys have any doubts, I want you people to very openly raise your hands and say that you have these doubts, because no doubt is small enough. No doubt is silly. Nobody is going to judge you for the lamest of the lame doubts you have. No doubts are lame, in fact. Okay? Yes. So moving on. Moving on. Right. Now we come to tiers of voting. So we have tiers in the sense at what level you're voting. This is a little extra information for basics, but I just thought it's good if you guys know. So we have international votes, wherein we argue against, or we go to international universities and we argue against law students from all over the world. Like I will go and argue against somebody from South Africa, somebody from the States, somebody from the UK. It's an international prop, and usually these votes, the law itself will deal with international law. So it'll be a case before the International Court of Justice or the International Criminal Court, etc. The second tier is your national votes, which is more prevalently common, where we see students from all across the country. We travel all across the country. And you won't see international students. You'll see students from other states and argue against them. So we have certain moods, like, for example, say for example, the cinema industry. We have all this IFA award, Filmfare award, and then we have Oscar. So what you see on screen right now is the Philip CHS International Moot Court Competition, which is like the Oscars of mooting. It is the top one pinnacle. It's absolutely undisputed. The picture you see, can all of you see the picture? The picture of the trophy that you see is the Jessup Cup, which is unfortunately it's not come to Soel ever, but you guys could be the ones making that difference. And the team that you see here is the team from Soel that went the farthest to Jessup itself. So they actually went to the international rounds and they were placed extremely high. They got out in like one of the last rounds itself. So and they've all passed out and they're like one of the seniors in Soel because they did Jessup. If you guys notice the trophy, it has these silver small boards, right? That board will have the name of every college and the students below of who have won the Jessup Cup. So I think India is there about 3-4 times because we've had a few Indian colleges that have won the moot, and you'll have their names there. And if you see, the last row will be empty because it's for whoever wins it next. So everyone, I think this is where the aspiration, this is like the height of aspiration when it comes to moods. And I really do hope that all of y'all like fight with each other to go to Jessup. Okay? Fight healthily. Don't like
exactly. The only part of the word only that's used in Article 15 Clause 1 comes into play now. What does it say? The state shall not discriminate against any citizen on grounds of only religion, on grounds only of religion, race, caste, sex, and place of birth. The word only plays a very vital role here. I'll tell you, how I'm saying only plays a vital role. Our constitution, as many of you know, is not a document that was completely made by the constituent entity. It took references from a lot of countries' constitution. And this particular Article 15 was referred from the African constitution. African constitution, it's almost verbatim same 15 clause 1 like an anti-discriminatory clause, except one, which is only kubadala, one or more of, they listed the same grounds. One equal one or more of அப்படிங்கிறதுக்கு என்ன டிஃபரன்ஸ் அப்படின்னு நம்ம பார்த்தோம்னா this case called Shreyas Singhal versus Union of India. And the case they would have talked about how law should be interpreted in the sense that the legislature has laid down in the law. For example, you have introduction to law now, right? The rules of interpretation or a brief on a understanding that in subsequent classes you probably get it. So there are interpretations to law wherein legislature எப்படி எழுதிருக்கோ அதை interpret பண்றது தான் ஜுடிஷியரியோட வேலையை தவிர்த்து judiciary should not go ahead, step and think about how administratively the law can be made effective. So the usage of only here suggests that whatever grounds are laid down in Article 15 has to be applied directly. It does not, Article 15, if they wanted, they would have included height here. They did not do it. They listed 5 grounds. So you're expected not to read into it intersectional discrimination அப்படிங்கிற ஒரு concept. You're not expected to bring into it the understanding based on Article 15 Clause 1. All right. This is the order in which you go about research. Once you're given with the Moot proposition is the factual matter of the case. So case pathana details, everything that they explain there, it is basically a holy grail. There is nothing else than the Moot proposition that explains the facts of the case. அதுல அன்னைக்கு ராத்திரி மழை பெஞ்சது 23rd August 2026 ராத்திரி மழை பெஞ்சது சென்னையிலன்னு கொடுத்துருந்தாங்கன்னா you're not going to explore weather apps. You're not going to check if it actually attained and contradicted. Whatever is given in the Moot proposition is exactly the kind of circumstances in which the hypothetical case happened. So the first source you have to refer to the Moot proposition itself. Or Moot memorial, before you start researching, before you start looking for precedents, before you draft your arguments, the first document that you have to be thorough with is your Moot proposition itself. என்னன்னைக்கு என்னென்ன நடந்தது, என்னென்ன இவெண்ட்க்கு அப்புறம் என்னென்ன நடந்தது, everything you're expected to know. And the second thing that you'll have to go for is the primary sources of law, which is constitution itself, the mother document. அதுக்கப்புறம் subsidiary statutes that are enacted. For example, let's assume I'm doing a Moot on surrogacy law. Surrogacy law, there are surrogacy acts separately that's enacted by the legislature, parliament and such. அந்த மாதிரி என்ன subject matter law பண்றோமோ cover to cover, you're expected to go through it at least once. Relevant provisions, there are certain Moot propositions that give you the provisions that you'll be referring to, but it's advisable you understand the context in which such provisions are. Because if Article 15, நம்ம இதுக்கு முன்னாடி ஸ்லைட்ல பார்க்கும்போது Article 14 and 15 go hand in hand. Because Article 14 talks about equality before law. Article 15 discrimination. So only if you understand Article 15 better, you get into the context of Article 15. அதனால whenever you're researching, the primary sources that you'll have to refer to is the constitution and relevant legislations that your Moot proposition wants you to handle. Other தவிர்த்து rules and judgments. Rules and there are parent legislation. For example, let's say IT Act of 2000. IT Act is the Information Technology Act of 2000. At the time of enacting 2000 வந்து என்ன level of technology இருந்ததோ அதை வச்சு மட்டும்தான் they could have possibly formed the sections of IT Act of 2000. Subsequent developments, so Orora should be amended, should be go ahead and introduce something as part of the IT Act of 2000 itself. In 2000, strike down panita should be reenact every time we have a technological advancement. Practically difficult. So you go ahead and form the concept of rules, where IT Act you will form authorities that will be empowered to make rules for them. So and the rules will form as one of the sources that you will absolutely have to refer to. Then comes your secondary sources. FCC Manupatra, commentaries, law books, journals, library resources, and all of it. First, source is Pato. Second one is your judgment, which is the FCC Manupatra aspects that we're talking about. you you're in Soel for 1 month almost now. One thing you absolutely have to give credit to Soel. Canteen complaint there's one thing that you have to credit Soel for, which is the amazing library resources you have. I'll tell you how exactly to navigate through the library resources. The first task for எல்லாரும் உடனே போய் லைப்ரரியில நிக்க வேண்டாம், because those faculty are going to bash at me calling saying இந்த மாதிரி freshers எல்லாரும் வந்திருக்காங்க. So one thing you can do is during the course of the week visit the library, and the entrance you'll have the reception desk, right? Go and ask them for IP login of Nimbus, KNIMBUS. Nimbus அப்படின்ற போர்ட்டலுக்கான IP login every single student here has. You're paying 3,000 for the separate access that's given to you for SCC, Manupatra and all these portals. Before getting into the IP access as such, I'll tell you what these SCC, Manupatra and all of it. SCC, Manupatra, light law and all of these are called reporters of law. Reporters of law now, for example, when a judgment is pronounced by the Supreme Court, there is Supreme Court website that has a documented version of the actual judgment. The original copy of the judgment is uploaded there. There are these people called SCC Online, Manupatra, Life Law, Case File. All of these websites are called reporters, wherein they report the copies of the judgment. SCC and Manupatra especially are recognized across the mooting fraternity as the binding source of the text that you provide to judges. Or judgment and court funding, you're referring to a judgment now, it is very advisable that you go for SCC Online or Manupatra. And the proceedings, put the judgments, they will report in a document format. So, theatre cases, it can be from SCC or Manupatra. We'll actually see as to how to access these portals by Soel and DNU. And next thing. So we have tndalu.ac.in portal, through which you can access the remote access IP login that I was talking about. You're paying 3,000 of your fees for this, so make note of it. And the portal you have something called the library as an option. Or toolbar you have library as an option, from which you can pick the research database website from the research database and research database outside the campus. Research database from the campus is in the library second floor itself, where you can go to the computer and directly log in and start using it. Outside the campus, you can go to a remote location, that is the home, and actually make the login as such. Okay, research database outside the campus. You'll have to sign into that portal. Then there's an option for sign in. Can you see an option block called sign in? You click on that, you get your details of sign in. There will be a login ID, probably your email ID and the password. Other one have to go and activate in the library. That's the reception desk. Ask you to ask for the details of such. Once you sign in, click on sign in, there will be one more portal wherein you enter your email ID and password. Of course, I'm not giving you my password. You're going to get your own. Go into the library, visit them, get your own password, and then click on continue. Once you log in, you will have access to all these databases, which is including corporate law, journals, EBC Reader, Seen Online, LexisNexis, Live Law, and SCC Online. SCC Online, the navigation, I'll tell you how exactly it goes. SCC Online, one source that I want to rely on. For example, when I asked you what precedent means, everybody said it means previous judgments. So when you're referring to a previous judgment, I'm telling you, my name is Nivedita Mahadevan. I'm going in front of the court in a Moot court competition saying Nivedita Mahadevan versus Union of India. They've laid down the principle that Article 21 includes right to die as well. Does that sound believable? No. So the judge is not expected to know every case law there is in the entire legal jurisprudence of India. So they are expected to give them a copy of the judgment or make something called the citation, refer to something called the citation. Citation of a judgment is basically a unique number and alphabet code that's given to each of the judgments to refer to each judgment uniquely. For example, let's say in the case of the Union of India, in the state of Kerala, it was a 1973 case, remember, it's you. 1973, my All India reporter citation would be AAR 1973, Supreme Court case, and a combination of numbers which refers to the volume of publication in AAR. So every such judgment that you're referring to will have a separate citation. So in the citation, the solicitors are going to make a judgment. It sounds more reliable because citation is something given by the court's record solicitor. அதனால SAC online would help you, like, find exact judgment is the same, and it's accepted in the Moot fraternity as such reliable document. So this will be with respect to research. So when you get a Moot proposition, you read through the Moot proposition. Apdi na சொன்ன மாதிரி it is going to make people that are taller in the class sit at the back by bringing them forward. The first thing you're going to do is thoroughly analyze each and every aspect of the same. Look at my intention in doing that. Look at what exactly the result of it. Look at like, the end result of it to see if there is a segregation between men and women that I'm trying to make. Once that is all done, you go to laws, which is Constitution of India, or the statutes, specific statutes that you're referring to. So once that part of it is done, you go to precedent. Precedent research, you have to use specific terminologies called the keyword search. Fatma, can you go to the next slide? Next. Next. Okay. So how to keyword search? I'll simply sum it up in a few words. Keyword search is basically where you tell the exact, you're not talking to a human being. You're talking to reporter apps as such. So you're going to give them the keywords through which you want your site to play. And there are thousands and thousands of judgments that you're going to look at. அப்போ உனக்கு தேவையான ஜட்ஜ்மெண்ட் எங்க இருந்து வரணும் அப்படின்னா you have to look at the issue that you're looking at. For example, நம்ம இடத்துல என்ன, what is the problem? Height segregation was a problem. So height is a little too specific. And then you go for something that talked about already, which is there is an intersectional discrimination wherein through height, I'm hitting at sex-based discrimination, which is covered under Article 15.1 of the Constitution. So my keyword search would be intersectional discrimination plus law. Law is under which article are we dealing with, this discrimination? Article 15. So intersectional discrimination plus Article 15 plus Supreme Court will be the keyword that you're looking for. If you place that forward, you'll get related judgments. If at all a court has gone ahead and reported judgment based on intersectional discrimination, height or being anything that comes within the ambit of the 5 grounds under which discrimination is prohibited. So this will be the search for you all, and then we'll go to the memo page alone. We'll run through the memo or drafting part of it. Research is the 70% of the work of a mooter. Once the research part of it is done, once you're thorough with what are the intersections that you're going to look at, what are the precedents that you're going to look at, when all of it is thorough, you go to the memo drafting part. We'll look through what are the components of memo, because Fresher'S most when you go for and register, which you absolutely should, by the way, you'll have mentors explaining as to what are the components of the memo and how is that to go about it. Components they can have. All right. So there is a front page which explains the cost cycle of the case. What are the cost cycle of the case? Which is basically you saying in the document format as to who instituted the case, against whom, which is basically you telling them who are the parties involved in the case and under which jurisdiction or which court you're approaching with this particular case. For example, Nivadita Mahadevan, the Union of India. It implies that Nivadita Mahadevan is the petitioner who went ahead and filed a case in front of a court. Versus Union of India, who am again instituting the case against the Union of India, which becomes the respondent party of the case. And I'll explain after which jurisdiction of the court that I'm stepping forward into. For example, let's say jurisdiction is basically the legal term for is a court empowered to listen to a particular factual matter of the case. For example, Article 32 is the jurisdiction, original jurisdiction of the Supreme Court, wherein fundamental rights violations, so you can directly approach the court under Article 32. So if I'm approaching the court under Article 32, I will say Article 32, Supreme Court of India. And here, this memorial is a memo that I presented to the TN and LU, mock trial competition. Here, the court is the commercial courts. Commercial Court Act of 2015, the commercial court that was established. So we went ahead with the commercial courts act. So the front page encompasses the title of the competition, You need team court that is allotted to you. And the jurisdiction and the jurisdiction as in which exact court are you approaching, and then something goes. And then the cost title of the case. In the case, there are three plaintiffs. Three people have instituted the case against one defendant, which is the respondent. And then to submit memorandum on behalf of petitioner the respondent. There's one thing that we notice in this document. This is the color of the front page, which is blue. The standard format is that blue is for petitioners and red is for respondents. When you so this is a plaintiff memorial, and the second page will have table of contents. Table of contents is basically you helping the reader of the memorial say locate each of the parts of the memorial. For example, I'm drafting issue 1 at page number 5 of the memorandum. They don't have to scroll to 5 to find out issue 1 is drafted there. There is a compilation of table of contents that's given in the next page. And then you'll have list of abbreviations. Abbreviations are short forms to words, right? So memorials are expected to be concise in nature. If something can be put in a short form, it would rather be put in a short form and not elaborated. If you're going to keep repeating the Supreme Court, Supreme Court, Supreme Court, you're going to take up a lot of space for memorial. And usually in most you have a limitation on the number of pages that you can put arguments for. And then what you do is you put a table of contents saying, if at all at any place I put the word yes and C, it means I'm referring to the Supreme Court. So there is a tabulation of all the short forms that you'll be using in a memorandum that's given, along with the expansion of the particular abbreviation that you're given. And then the provisions of statutes referred and the books and books referred, all of them come under the same tabular format. So you'll have something called the case laws referred to also. This is the index of authority. So any case that you're citing, you're expected to have that as the tabulation. And then the cases are in the page, the citation order is supposed to tabulate all of it. We come to the most important part of it, which is the statement of jurisdiction. Jurisdiction, as I stated earlier, is a particular section of law or provision of law that empowers you to approach a particular court. So in this present matter, I've approached the commercial court under 3 specific sections. So all of these are compiled and written together. Stating the plaintiffs have invoked the jurisdiction of the honorable court under so and so sections. After you will complete it. And in the respondent memorial, you are supposed to add a line stating the respondent, however, deserves the right to dispute the jurisdiction, which is in the sense there are issues on maintainability. In the jurisdiction, the respondents are expected to argue. So, a memorandum statement of jurisdiction is going to make a statement stating these are the jurisdiction. To seem like you're not acknowledging that there exists a jurisdiction, you add a line saying we serve right to dispute the same jurisdiction. And this is the footnotes for the jurisdiction that I've given. How many of you know what a footnote is? Okay, so those of you who do not know, if you're referring to a provision of law or case law for that matter, we add something in every document that you go through. So you're basically telling the reader to refer to so and so places to see where I got that statement from. I'm generally making a statement that right to privacy is part of Article 21. I cannot, on my own capacity, go ahead and make it. Maybe I'm probably referring to a case, for example, case Swami was the Union of India. So I'll make that statement in the document and put a footnote saying this particular statement I took from the case Swami was the Union of India document. So this is the purpose of footnote. And then you have statement of fact. Statement of fact is you concisely summing up for the convenience of the bench, that is the judges that are assessing you, as to what exactly is given in the proposition. Propositions are, start from being a minimal 2-page document to 36, 60 pages document also. So, more proposition are 60 pages, you don't expect the judge to read. So, you concisely sum up exactly what is said in the proposition neutrally. Petitioner memo, petitioner favor, respondent memo, respondent favor, you are not expected to read. You are going to state this is exactly what the proposition deals with. And so, issues that are being presented in the case, which is presented in the next page. Obviously, move on to the next page. This is a statement of issues. Usually, the Moot proposition in itself gives you a list of issues you are expected to deal with. You just have to list it down. If the proposition does not come with a set of issues that you are dealing with, you have to find out what exactly is the legal dispute that is arising in the case and frame your issues accordingly. Next page. And then summary of arguments. This is basically, again, for the convenience of the bench. There is something called argument advance you'll be doing later, which is you absolutely breaking down every bit of your argument. For example, in the research section that I gave you, if I'm going to say height will come under under Article 15, summary of argument, they're going to sum up based on keywords as to why exactly do I think so. Other படிச்சோடனே they are supposed to understand what your contentions are. So this is usually a 1 or 2 page duty that is supposed to do. Next. And then arguments advance. So then you'll have something called limbs and sublimbs. For each of the issues, they are expected to break down each of their argument into a structured format. For example, if I'm going to talk about discrimination under Article 15, and I'm trying to institute a case in front of the Supreme Court, firstly I'll deal with what exactly Article 32 empowers me to do. Article 32 jurisdiction, if I'm approaching the court, I'm going to tell them Article 32 says if my fundamental rights are violated, I'll be given the power to approach the Supreme Court directly. And then the next limb of my argument would be how exactly is my fundamental rights violated? முதல்ல 32 நான் வந்திருக்கேன், you justify it by saying because there is a fundamental right violated. And then the next limb of argument would be how exactly was my fundamental rights violated? For example, Article 15 has these 5 limbs. And then for a sublim, for the same, you'll be like, sex-based discrimination can be seen from height-based discrimination. You'll provide your sources for the same in the footnotes. Like that, you're going to break down each of the legal arguments that you're going to place forward for each issue. From the scroll all the way up to the prayer. Okay, so argument advance is basically that you're going to break down all the research that you've done into structured arguments so that when reading it, it makes sense. The last thing that you'll ask for is the prayer. Prayer is that part of the Moot proposition, which the Moot memorandum that you'll be submitting, which says what exactly do you want the court to do. For example, if I'm approaching the court under Article 32 saying my rights are violated, is it okay if the court says yes, your rights are violated and we such and the boy continues to sit in the back of the INSA? No. So you're asking for some sort of a remedy or some sort of a striking down of a law or some sort of direction to the state or anything that you're asking the court to do to be listed as a prayer. So there is a particular format to it, and there is a for the Fresher'S Moot Court competition, when you're signing up, there will be a handbook that's given to you. You can refer to the handbook to see exactly what goes in your memorandum and all of that. So you're basically expected to understand what exactly is expected of the court and list out as part of the memorandum. So this is basically with respect to research and memorial. Once you're done with the research, once you're given the Moot proposition, read through it multiple times, 5 to 7 times, and then look at the law aspect of it. Once you're sorted with which are articles and which are the sections that are involved in your research, you go to precedence part of it, then something your Manupatra, HCC online and all of those. Once you find relevant case laws that are in support or against your argument, you jot it all down in a structured manner, and then you come up with something called the Moot proposition or Moot memorandum that you'll be submitting for both petitioners and respondents separately. So this is with respect to research and memorandum drafting. Is there any doubts? Can you be a little more louder? Are you sure? Paka. That would be all. We'll be listening to oral arguments part of it in a little more depth by our Vice President, Ms. Monica.
Thank you, Ms. Nivedita, for breaking down the intricacies of the art of crafting a memorandum. I'm sure these aspects will come in handy during the Fresher'S Moot preparation. So moving on, now that we've explored the legal research and drafting aspect, ultimately advocacy demands something more. It demands our voice. Oral advocacy is not merely the art of speaking, it's the art of communicating an argument with such clarity, confidence and conviction, and of course a deep reverence for the bench. Turning to this crucial aspect of mooting, we have Ms. Monica, the Vice President of the Moot Court Association, who will be speaking. The stage is yours.
Thank you, Tejashya. Good morning, everyone. I am Monica. I am serving as the Vice President of the Moot Court Association for this year. So how are you all doing today? Good? Okay, did you guys understand everything which was explained by Mariam, Nivedita? It was all a little overwhelming, no? Yeah? Okay, I understand, okay? So let's just keep it very chill, okay? oral advocacy is the fun part of the book. Okay, let me be very, very honest with that. It is extremely fun. So, and we'll also try to keep it very lively. Okay, I want to have an interactive session, considering it is about oral advocacy, right? So, I'll just keep moving here and there. You can just see me ask questions. Okay, and we'll just talk what oral advocacy is about. Okay, so you saw, Nivedita explained beautifully about what research is, what memo drafting is. So what did you guys understand from what a memorial is? Great. Yes. Now, you have in movies and all, you have seen these advocates carry all hefty bundles, so many documents they have. So in Moots, we call them as memorials. Okay, we don't put it in a docket. We just have it in a soft binded file. Okay, it is memorial. Now, when that is done, you have everything prepared. You've researched thoroughly. You've put it in your memorials. Now you have to go and talk to a judge. Okay, so they have given you a site. You have to represent the site. You let's say you get to be the petitioners for the round one, right? You get to talk to the person who's filed this case, right? So your job right there is to convince the judges for your client, okay? And you are the advocate there. You are the counsel appearing behalf of the petitioners. Now, right there, when I said this is the counsel appearing on behalf of the petitioners, right? This forms a part of the courtroom manners. Okay, you don't go into a court hall and say, "I am Monica. I am representing the petitioners of this case." Right? No, you represent yourself as a counsel. You are like, "This is counsel appearing on behalf of the petitioners, so and so." Right? So you are not your own individual. There, you are counsel representing your client. Right? So that forms a big part of what an advocacy is, right? And when you do Moot specifically, it is just training you to be an advocate at the end of the day, right? When you do research, when you do a memorial, it's the skills are just, you're enhancing all your skills in drafting and in researching. And now when you get to go to court and talk, in real courts, let's be very honest, the judge will only be hearing you for 2 minutes. In Moot courts, they'll be hearing you for 20 minutes, right? So what you're trying to do through Moot courts, you're trying to train yourself in this 5 years of how you can convince the judge when you do go for practice in 2 minutes by practicing in these 20 minutes or 10 minutes, which is allocated to you in a month. Okay, very simple. This is what oral advocacy is, right? Now, how do you convince a judge? Every pesna, they'll understand how, what you're trying to say and when will they be impressed? Okay, so we'll start with, a small formula kind of thing. Okay. When you talk about oral round, it is going to be about content, going to be about structure and how you deliver it. Very simple. Content, structure, and delivery. Right? So if I do come here and try to just give you whatever is written in my memorial, if I'm just gonna read it, will you all be interested in hearing me out? No, right? It won't be that nice. You would be like, oh, the guy would read the PPT itself, or I would read the document itself, whatever you send me. That won't be that nice, right? So the way you deliver your argument is extremely important. Now let's say you've put in all your research, you've drafted a memorial, one issue deals with 5 pages. Now you can't go to the court hall and read those 5 pages. Okay? Now this is where you prepare something for your orals, right? I usually have a separate oral script, okay? And a few people, they mark the point, the argument they want to present in their memorials itself, okay? So now all the important crux, okay? Now let's say I have two issues. I think Nivedita explained about Article 14 and 15, right? Now there's a violation of Article 14 and 15, and she also spoke about jurisdiction. Now my first issue will be maintainability, okay? I have to argue if this case is maintainable or not. Now, I will structurize my argument in a three-limb manner. Okay, I will tell you, Lordship, the council will be arguing this particular issue in a three-limb manner. The first limb will talk about how the fundamental rights have been violated and how the council will be proving it in the further argument. How this is filed by an NGO or a non-beneficiary body. That is why this PIL is entertained. And the third will I'll be giving them precedence and everything. Right now, I have structured my arguments. And it is very important before you begin your arguments that you give a roadmap to your judges. Okay, so they'll be able to understand and they'll know what to expect. So if I just started talking, I'm just going out of nowhere, okay, and I'm just covering a lot of topics, it is very hard for you all to keep in track with. So I started with a formula. I said content, I said structure, and I said delivery. Now you guys know what to expect from me, right? You'll be expecting something from all these three topics. And now content is majorly dealt with research and what you put in the memory, right? Which was already dealt with. So now you have an idea of what a content is. Now, when we talk about structure and delivery, it forms a huge part of oral advocacy. Okay. Now, when you do give a roadmap, when you come back to structures, right, the judges will know, okay, so this girl will be dealing with this particular issue and she has three arguments. Okay. And now we'll go in depth with the arguments. Now, you can't go to the judge and say, see, he has violated my fundamental rights, thereby this PIL, we have Article 32. When a fundamental right is violated, I can come to the Supreme Court. That's not how you say it, right? You'll first lay down your legal principle, okay? And then you will, you'll make an argument of how it is relevant to your factual matrix, okay? Now, there is a fundamental rights violation, but how has it been violated? How is your client affected? Is there any injury, right? All these things you'll be explaining to your judge through oral advocacy, right? So you'll start with your legal principles and then you'll come back to the factual matrix, right? And then you will go ahead and you will say the relevant precedents. Now, a lot of people knew what precedents were, right? Right? Now, how do you pick precedents in when you come to oral advocacy? You pick there will be a lot of precedents that you rely on for violation of fundamental rights. But which one do you pick? You pick whichever is the most relevant to your case, the factual matrix, right? And you pick a judgment which has not been overturned. Overturned in the meaning which has, it's still valid and another judgment has not come striking before one term. Okay, that is an overturned judgment. Now you come and you tell them the most relevant, the most recent judgment. Okay, and now you have a perfect argument which you can deliver because you have told them what your legal principle is. You've told them, how it is relevant to your case, and you've also told them there are cases before this, and what they are held. You're supposed to give me a prayer for the same, right? Now that is how you structure it. You start with a roadmap and then you structure each and every argument in this format so the judges know, okay, so this girl has read something and she has also prepared because she has that and structured it. Now, structuring does not come automatically, right? Only if you sit and prepare, you'll have a structure that is set in your mind. So the judges automatically will feel like, okay, she has good content, she has prepared well, and she's delivering properly. Now, when we do come to delivery, the whole lot of courtroom manners comes into place. How you approach the bench, how you talk to a judge. From the very beginning, you go sit in court hall, okay? You have a moot representation where they'll be demonstrating of how the works and how you get to talk and everything. But just for you guys to understand of why they are talking this way, right? There are judges, there are counsels here, okay? And we are trying to get an order from the judge, right? You don't have the liberty to go say, hey, this is what has happened. You need to give me this, right? There's the reason why the judges are judges and why we're the counsels, right? We are representing a case and they are in a position where they can give you a review. So whatever happens in the courtroom, it must be extremely cordial. It must be extremely polite and very, very respectful. That's the reason why we call them lordship, ladyship, right? Because that is the amount of respect in judiciary from the colonialism and everything that we give to the judges. So let's even start. How do you approach to the mic? Say we have two parties sitting here and there. Now it's your chance, okay? How do you go and stand the mic or stand in the middle so you get to start the class? You ask, the council seeks permission to approach the podium, right? You are in the podium and when you want to start, you seek permission to begin. The council seeks permission to begin the argument, right? And then you seek permission to start with the statement of fact. And then you ask permission to begin with your argument, okay? And now that comes the important part. Judges will ask questions. Okay? Now, how many of you are all very scared of questions? You know everything. You are, you've researched very well. But when someone puts you on a spot and asks you a question, I'll get scared. Right? It happened. To be very honest, it used to happen to me also. Okay? I was not very eloquent. I was not great at English and all. And it is a very big myth. I think Mariam also previously said, oh, if I'm good at English, I can do a book. If I'm not good at English, I can't do a book. Right? That is no way relevant to what mooting is. Right? It is all about you learning how to argue, and it is all about, framing arguments in your head and delivering it. English is just a tool. And as Mariam said, we also have Tamil notes and everything, right? So when someone puts you on a spot and asks you a question, when I was in my school, I would stammer. I'll be very honest. But then as I did more, I started enjoying all these questions. To be very frank, if a judge asks you a question, it only means they're listening to your arguments. Because without listening, they'll not be able to ask questions, right? So it means the judge thinks, oh, this girl seems to know something. Let me pose her with a question and see how she answers. And only when they ask a question, no, supposed to be extremely confident and say, much obliged, your lordship. The answer for this is so and so, right? And even if you don't know the answer, I wouldn't ask you to, just go around the bush or something. Take your time, say, you have the assistance of your researcher during the moot. You say, the counsel would like to get back to the answer towards the end of his or her arguments, right? Be very confident, okay? And I am pretty sure, whenever they ask me a question, I do this one thing. I'll start off very smiling and I'll be like, much obliged, lordship, thank you so much for the question. I'll not answer in my head. And as I start talking, automatically, because you've researched so much on one topic, as you speak, the answer for it will just come to your mind. They say this saying, like, exam hall poi, once you start writing, once you see the paper, you'll know all the answers. The same thing. Okay? Once you try to answer it with full confidence, I am pretty sure you will be able to answer. Just make sure when you come to oral advocacy, you have, there is a tendency that it might go off a little, right? So you'll have to be extremely polite, and you'll have to come along with all the courtroom manners and answer it properly, right? So that is the biggest part of courtroom, that, is what oral advocacy is, and why courtroom is extremely important. And now, when Nivedita explained what a prayer is and everything, do you guys remember what a prayer is? Right? Any more answers? Yes, perfect. Yes, okay. You are asking for whatever you need, whatever from the court, from your side, okay, from your representation. But how are you going to deliver the prayer to the bench? Only by written form? Oral advocacy. How will you say? You'll finish all your arguments. You tell them this is the law, this is the facts, this is the relevant thing. You've dealt with all four issues that is given to you by your other counsel. And then what? You'll have to ask them the prayer, right? How will you ask them the prayer? Yes, you will request them. But when it comes to the prayers, if you see the prayer page in your memorial itself, you'll have like a paragraph. In the paragraph, if you do look into it, only 3 lines maximum will be what you're asking for. The others will all be the counsel humbly request for the bench to declare so and so, right? That is what oral advocacy again is. You will be asking for the bench to give prayer to you. And one heads up is you don't say the prayer by looking at it. Okay? Soel students are known for by-hearting the prayer and, looking at the judge and telling. And now, I forgot to completely cover, right? How will you give your arguments? You've prepared everything, you've structured it. Are you going to look at it and read it out? No? Then how are you going to say it? So many content, so many case laws, so many citations that you have to tell. How are you going to do that? Seems like, such a big thing, you have to remember so much. Why do all those things? Structure it, right? So you develop an act, you habit of only referring it because you have researched, you have structured. you know what you're going to talk about, right? So you only refer to the argument and you speak it in your own pace. Okay? And when you do that, you will develop your own eloquent way of delivery. Okay? You can take a lot of inspiration from a lot of mooters, from a lot of advocates, and try to incorporate it in your oral advocacy. But at the end of the day, it is you who are delivering it. So you do refer to your script, you do refer to whatever you've researched it, and you try to deliver it as the way you want. Okay. Now, can we have like a little bit of interaction? Now I'll ask you a question, and I'll give a bad answer. Okay. And I want like a very good answer with all the courtroom manners involved and more eloquent and more formal and professional. Okay. So the judge is going to ask me, what is your case about? Okay. And like a bad, like a person who doesn't know what will be my answer. I'll be like, the lordship, this case is about violation of Article 14 and 15, your lordship. And natural justice and legitimate causes are also affected. Right? But how would a proper advocate who knows how to deliver it in a structural and in a polite way? Do we have any volunteers? Does someone want to try? I know you have to deal with, so I'll tell you the answer. The answer would be, your lordship, the counsel for the petitioners are here to are here with a terminating order or like whatever your case is about in the first place. And the first ground is about the violation of fundamental rights, which deals with Article 14 and 15 in particular. Adding on to that, the second ground for this particular case deals with the violation of natural justice and the legitimate expectation principles. Okay. Now, what have I done? I've just not said this is that. I've also said these are the grounds for why I've appeared here, and this is the first reason, and this is the second reason. Okay, and I've told them in a very proper, little fancy way where they know what to expect from you. Right? So this is how you develop your oral advocacy, even in the simplest form. Now, moving on to the next. This will be the last part of it, and then I'll wrap it up. So you guys have a mock moot coming up, and you can actually see how oral advocacy works and everything, right? So the next part is how you apply, how you cite a judgment, right? Now we have spoken about how you'll pick a judgment, how you'll do research, how you'll find a lot of judgments, right? But when you do come to the court, and when you do say it in the oral advocacy, how will you say it? In this particular case, in Menaka Gandhi versus Union of India, they have said Article 14, 19, and 21 must be interpreted together. So you have to do the same thing for this case. No, right? You see how the factual matrix of that particular case and this particular case has, relevant, and you read out the legal precedent. You take inference from the ratio of that particular judgment. Now, any of you know what a ratio decidendi is? Very good, right? The reason of why they've given the judgment, right? Now you will take that reason, you will state that reason, and then you will tell them how that reason is useful for this particular case. And develop this one habit, of stating the citation along with the case title. Now, Nivedana explained of how, citations are so important because that is like the reference point to know how much you have to which case that you have referred to, right? And in that particular case, when you do tell them in oral rounds itself on how the case title and the citation along with the legal principle which is applicable for your case, you develop a wholesome argument of how this particular case which has been already established is favoring your particular state. And now the same goes for both the sides, right? And one trick in oral advocacy is since you're preparing for both the sides, you know what your opposite party is going to talk because you have prepared that also. So it is only about, like thinking in a very interesting way of how you get to talk for both the sides. Now let's, just take a small example of fights at your home. Imagine you have siblings, okay? You you're just gonna talk, you're just gonna complain to your mother of how your sibling hit you. Okay? And now again you're put into a spot where you also you have to talk to your sibling. Okay, how you have to prove that you did not hit your sibling, correct? So this is just like a very interesting phase in mooting where you get to represent both sides and you know what your opponents are also argue about. And like this one last part about rebuttals. Now your arguments are over, okay? And now the question and answer phase comes where your opponent counsel is going to ask you a questions about your arguments and you get to answer to them. The petitioners will go first and then the respondents will, right? And even in this, you've only been given like very short time, okay? And you've been given 10 minutes. You have to answer to your questions, in a way that it impresses your judges and also shuts the mouth of the opponent counsel, right? So your rebuttals, your oral advocacy is going to be like, okay, how is my answer going to be extremely, in a very extremely crux format, which will shut the judge's mouth and my opponent's counsel. Okay, that is where you use all your rage fighting skills into purposes, and you will come in a very again in a very formal and a decorum way, using all your court manners, and you will come ahead and you will say, this is the answer. The counsel for the opponent counsel might have missed it and everything. So your oral advocacy starts from giving your arguments and even to a smaller pace where you're just delivering your rebuttals in a minute or two, right? So all of it, when you do go for the rounds, everything is a part of oral advocacy. And it might be a little, nervous. When I started mooting, I used to have this very nauseous feeling before I did my oral advocacy. I was like extremely, scared and everything. Even now, before I started talking, I was like extremely nervous. But then once you do start talking, once you do get a hang of it, it becomes the most fun thing. When you stand on the podium and when you do start talking, it makes you feel extremely alive, because something that you've sat in your room and you've researched for days and days, it's finally coming to life, finally showcasing all your skills to the judge. Okay? And that will be about oral advocacy. Okay? You guys have any doubts? I think I've kept it a little very simple and also have a time constraint. Yeah. Do you guys have any doubts? I'm pretty sure like once you see the mock moot, you'll have a better understanding. You have a little games and everything, and you get more doubts. Okay. Have a great day. Thank you, guys.
Thank you, Ms. Monica, for that engaging session. We all feel the voice within us. As the famous Albert Einstein quote goes, in theory and practice are the same. In practice, they are not. To give us a practical understanding of how a moot court competition functions, we now have a mock moot demonstration by the second year member representatives of the Moot Court Association. Kindly requesting Mr. Ashwat Dinakaran, President of the Moot Court Association, and Ms. Mariam Amin, the General Secretary of the Moot Court Association, to preside over the mock moot. Thank you. Now, to our dear freshers, we invite you to observe very closely. Over to our second year member representatives.
May it please this honorable board, the council seeks permission to approach the dais.
Check. Yeah. We thought we'll just give you a brief as to how this event is going to go so all of you can understand. To our right, we have the team, which is representing the respondents. So on a courtroom, always understand that the state is right. like right side, or like you want to presume that the state is always right, you can do so. But the ideal is that state always goes to the right, and on the left you have the petitioners. So as the on our right we have Ms. Sharon Deborah as the first speaker, Indian as the second speaker, and as the researcher we have Ms. Nitila. And for the petitioner side, we have Ms. Monica as the first speaker, Mr. Kavin Kumaraswamy as the second speaker, and Mr. Aditya shall be the researcher. So every team inherently, this is not for your freshers mood, but this is basically how most of the moods function. So you will always go as a team of three, as Mariam has taken a considerable time to explain how does the team composition work. We're just showing you a mock mute simulation as to how a mood will basically go. If I may please take a moment, from Monica alone, so you guys will be able to understand the proposition which we are currently arguing. I'll just request Inian to give you a 1-minute brief. The proposition is already shared in the invite which is sent to you in your WhatsApp groups. If you had already read, it's fine. But even otherwise, Inian will just give you a 1-minute brief as to what this proposition is about. Trust me, all of you already have some idea on this. Inian will just tell you what are the, a little on law as to how this basically functions.
I'll just like to add one more tip to clarify. This proposition is for this mock mute simulation. So don't confuse it with your freshers prompt. Your freshers prompt, we will send it to you later. Keep these facts in mind to understand what they are arguing. Okay?
So hello everyone, Indian here. I'll just take a moment of your time. So basically there is this country called Union of Aryavarta, and in Union of Aryavarta there is a state called Drago. So as we all know, the governor is the constitutional head of the state. So the state assembly of Drago throughout a course of 3 years from 2020 to 2023 is passing 12 bills on various matters. And these bills, they'll be sent to the governor for getting assent. So similarly, how in parliament they pass bills and it has to be getting the assent from the president. Similarly, we have the governor within the state. But however, out of the 12 bills, the governor exercising his powers. So the article which is concerned to the governor is Article 200. So under Article 200, he is reserving 2 bills for the consideration of the president, and he's sending 10 bills back to the state legislature. And the state legislature is passing all of these 10 bills once again and sending it to the governor, under which he should have given assent to all of those 10 bills. But however, the governor, exercising his so-called powers under Article 200, is reserving it once again for the reconsideration of the president. And now the state is left in a situation where it does not have any sort of remedy. So it has approached the Honorable Supreme Court in order to lay down guidelines and time frames for the governor to act on the bills and specific frameworks with regards to Article 200. That will be the proposition subject matter. And I think we can proceed with the permission of the judges.
How many of you followed with what Indian just said? Have any of you read the news on this issue? Can we get a raise of hands? You. Okay, but did you understand what Indian said? Yes? Not everyone? Yes? I think after you guys can pick up from where they are. May it please this honorable court, the council seeks permission to approach the judge. This is the Advocate General appearing on behalf of the State of Draco, along with my co-counsel in the case of State of Draco with the Secretary of Governor of Draco. If it is of no inconvenience to your ladyship, the council seeks permission to address the bench collectively as your lordships. Proceed. Much obliged, your lordships. The council seeks permission to serve a copy of compendium to the honorable bench. To clarify, she just asked me a question. Because usually ladyship, female judge, lordship, male judge. If you want to collectively address them, you can't say ladyship, lordship, ladyship, it gets confusing. So we say lordships. So if there is a female on the bench, that's why she just asked me a question. If it's of no inconvenience to her ladyship, can I collectively address the bench as your lordship? To which I agree. Just keep these pointers in your head for your good. Would your lordships appreciate a brief perusal of facts? The state of Draco, a constituent state of the Union of Aryavarta, passed 12 bills between January 2020 and the April 2023 and transmitted them to the governor under Article 200. The governor kept the bills pending for periods ranging from 18 to 36 months. On November 13, 2023, the governor withheld assent to 10 of the bills without providing reasons. The Legislative Assembly reconsidered and repassed the 10 bills in their original form on November 18, 2023. On November 28, 2023, instead of granting assent, the governor referred the bills to the president under Article 201. The state of Draco subsequently approached the Supreme Court under Article 32, challenging the constitutional actions concerning the bills. The issue is whether such a petition by the state against governor is maintainable under Article 32, particularly in view of the governor's immunity under Article 361. If your lordships are satisfied with perusal of facts, the council may proceed further.
Just so everybody knows, what she presently presented were the facts of the case. So you will be given a moot proposition which might go for a bunch of pages, but you cannot waste the court's time reading every paragraph of it. So you're supposed to concise that and briefly tell us 5 sentences of the facts as to what basically the case is. That is exactly what she did. And after she completes it, she asks if your lordships have perused the facts of the case, may the council please move with the arguments, because she has already given us the issues. She read out both the issues which are presently before the bench, and now that she has read the issues, she's going on to ask whether if you're convenient with moving to the arguments. Please proceed, council.
Your lordships, the present council will handle the first issue, and the second issue will be handled by my co-counsel. The first issue before this honorable court is whether the writ petition filed by the state government against its constitutional aid under the Article 32 is maintainable, or it is barred by the personal immunity granted to the governor under Article 361 of the Constitution. I'll address my argument in 2 brief limbs, your lordships. My first submission is that the present petition is maintainable under Article 32. I respectfully submit that, your lordships, the state is not claiming any fundamental right for itself. The state is approaching this honorable court in the collective interest of its people who are affected by the continued inaction of the governor. Your lordships, these bills have been passed by the state legislature for the welfare and the benefit of its people, and therefore by keeping these bills pending indefinitely, it directly affects the citizens who are intended to benefit from them. Thereby, it is affecting their rights under Article 14 and 21. Your lordships, in the case of Maruram, Miss Union of India, this honorable court held that all the public power, including...
Counsel, can you please tell us the citation of the case you're relying upon?
Certainly, your lordships. It is reported in 1981, 1 SCC 107.
Proceed, counsel.
Much obliged, your lordship. In this case, it was held that the public power, including the constitutional power, must not be exercised arbitrarily or maliciously. Therefore, in this present case, this indefinite and unexplained delay of giving assent to the bills has not followed the constitutionally permissible course, and it thereby amounts to arbitrary exercise of the constitutional power, and it consequently violates the Article 14 of people. With respect to Article 21, your lordships, the right to life is not confined to mere physical existence. This honorable court has held that life means more than mere animal existence, and it includes the live with human dignity.
Where has this court held that it's not clear?
Your lordship, the council pleads ignorance. Your lordships, specifically,
We'll
this
take a moment to explain. So the specific question asked by the judges as to what is the citation. I think Nivedita during her research has taught you what citation is. So every case will have a basic identification number and a reporter. So she was very prepared on the citation part. She told us. But then we asked him, what is the facts of the case? So you rely upon a case. You have to be knowing in very brief as to what are the facts of the case. All you have to do is basically, there are many head notes in judgment. So if you're relying upon a case, ensure to have a very two sentence facts written on your oral script itself. So when a judge is asking for it, you all the more present. We have deliberately instructed her to plead ignorance so you can know what do you say when you do not know an answer. So say, for example, you are not prepared. You cannot just stand idle. You cannot expect the bench to, understand what's on your head. My lord's, counsel pleads ignorance. You plead ignorance is the fact that you did not know. So, there are a lot of languages where, courtroom language basically. So when you say the counsel pleads ignorance, it's presumed that you do not know. And then you go on to proceed. Understood? Thank you.
Your Lordships, specifically, this Honorable Court has entertained petitions filed by the state governments under Article 32 in certain cases like the state of Telangana with secretary or to governor and the state of Punjab with principal secretary to governor concerning the governor's inaction under Article 200. These decisions demonstrate that there is no absolute constitutional power on a state government in invoking an writ petition under Article 32. If your lordships are satisfied, I will move on to my second submission that Article 361 does not place the governor's official actions beyond judicial review. Your lordships, Article 361 provides personal immunity to the governor from being made answerable before a court. But personal immunity is different from the immunity of the official action itself. This distinction was recognized by the Constitution Bench in the case of Rameshwar Prasad, this Union of India, where this Honorable Court made it clear that the personal immunity of the governor does not prevent a challenge to the governor's actions. This principle is also supported by decisions of this court in cases like S.R. Bommai with Union of India and Quixoto Holhan with Zachilu, where exercises of the constitutional power were held to be justiciable.
I understood your argument, counsel. You can wrap up in your book on.
Much obliged, Your Lordship. Counsel will take the dice.
The council seeks permission to address the bench as my lords, if it is of no inconvenience to your leadership. My lords, the issue too before this honorable court is whether the Supreme Court, in exercise of its power under Article 32, read with Article 142 of the Constitution, can prescribe binding time frameworks for the governor under Article 200. It is respectfully submitted that the answer to this present issue is constitutional. It is present in the constitutional scheme of Article 200 itself, my lords. I will advance my submission under 5 limbs, my lords. My first limb of submission is that the Article 200 prescribes a complete constitutional scheme for the consideration of a bill, my lords. However, my lords, when a bill is presented, the substantive part of Article 200 provides 3 options to the governor: to assent the bill, second, to withhold the assent, to reserve the bill for the consideration for the president. It is the third option, my lords. However, these options are not restricted. What the Constitution prescribes is first to look into the bill, whether it is a money bill. If it is a money bill, it cannot be reconsidered. Second, whether the bill would derogate the powers of High Court, then such a bill should be presented before the president for the consideration, my lords.
How is this even the Supreme Court's problem? Our powers under Article 32 is specifically confined to directing authorities which come under state. Do you want this bench to go and issue a mandamus against the governor of a state? Do you think we're empowered to do that?
Certainly not, my lords. Here, the respondent is being the secretary of the state, my lords, who is representing the governor, and we are not challenging the powers of governor, my lords. We are asking the enforcement of such power, that such discretionary power, so that it does not lead to arbitrariness, my lords.
So you're not challenging Article 200?
Certainly not, my lord. And we are saying that Article 200 is very limited, my lords. It is not unrestricted. It has certain safeguards, and it has 2 provisos, my lords, which would be further discussed upon, my lords. Okay. May I proceed?
Just a second. So team, if you look at, this was a specific legal question posed to the council. So at times, while the council is arguing, you will have your own pace of script, everything is fine. But the judge will not wait for your pace to end. So at some point where we believe there is a legal question to be asked, we'll specifically shoot to the council, and that question has to be addressed. If you looked at the way, Kavin addressed, he goes on to directly answer the question. So number one, it was a direct question. Do you think that this court can issue a mandamus against the governor? That is basically a yes or no question. And as all the more, his answer was not no. If you look at it, it was certainly not. So there is always a level of modesty you maintain towards the bench. You do not say outright no. Like, no, that is not how it works. No, it will not happen like that. You say certainly not, my lords. So you can, like, the ideal notion is that you have to understand that the bench, it all comes from a place of colonialism where we always respect the judges, and we seem to absolutely submit ourselves to them. So the way you have to put forth is that certainly not, my lords. And then he goes on to explain the provision. So he always starts it with provision as to how he is basically not challenging Article 200 in itself, but saying that it will just be arbitrary if the governor sits on the bills for the longest amount of time. And then he asks my permission, as to whether I'm convinced. And then he's asking, can I please continue my submissions? And then he goes on to do. That is exactly what is expected of you on the bench as well. Proceed.
Certainly, my lords. My lords, the first proviso of Article 200 states that the governor shall return the bill together with a message requesting the legislator to reconsider the bill, which is stated in the particular message, my lords. But in the present case, the governor did not give any particular reasons, my lords. He only stated he withholds that particular bill, my lords. My lords, further, when we look into the proviso, at the very end, it is significant to note that particular point, my lords. If the legislator passes the particular bill, again, with or without amendments, the governor shall not withhold the assent therefrom, my lords. So there's a shall clause which mandates the governor to pass the particular bill, my lords, by giving the assent, my lords. My lords, this expression is very important because it demonstrates the constitutional character of governor's veto, my lords. My lords, under the constitution, the governor, what possesses may be properly described as a suspensive veto, my lords, not an absolute veto, my lords. My lords, this principle was also appreciated in the case of state of Telangana versus governor of Telangana, my lords. My lords,
Which court pronounced this judgment, counsel?
it was pronounced by this honorable court, my lords, Supreme Court, my lords.
Can we please know the composition of the bench? What was the quorum?
Three judge bench, my lords.
Okay. So again, if you look at here, the number of judges which preside upon a judgment is very important. Now, if you look at Supreme Court almost 95% always sits in division benches. So there are always two judges sitting on a bench and deciding one matter by the Supreme Court. So however, you can go to high courts and check, you have single judges and then you have two judges. A two judges bench is called a division bench. And if it's three judges basically come in where there are multiple propositions of law concern. Say, for example, a division bench says that this proposition can be allowed. And then another division bench parallelly holds that this proposition cannot be allowed. That is when the High Court's Chief Justice will form a full bench where three absolutely different judges will sit on the bench and decide the matter. Now, three judges bench is called a full bench. I want you all to take a note of this because all of this is essentially what you will be asked in your Fresher'S mode. So a single judge bench is called a single judge bench. Two judges is called a division bench. Three judges is called a full bench. 5 judges is called a constitutional bench. Anything above 5 will always be in an odd number. Why do you think so that happens? Why is it not 6, 8 or 10? 10 is a very round off number. Why does the Supreme Court or any court does not do that? Very good. Can I please know your name? Yeah, good answer, Ovia. So Ovia, based for the people who did not hear Ovia said that when a decision is being taken, judges cannot keep quiet. They cannot say that I will not answer yes or no. There should always be, you either have the option to allow the petition or dismiss the petition or dispose it off. Dispose it off is basically where you have different set of instructions to still dismiss the matter, but still it gets partly allowed. So these are basically the options. So if essentially every judge is mandated to take a decision to allow or dismiss, it has to be in an odd number. That is when they say 5:4 majority, 3:2 majority. So 3 people have assented, 2 people have dissented. Assent is basically allowing, dissent is basically dismissing. So that is all the more the ratio. So when we are asking what's the quorum, you have to tell what is basically judgment. So say for example, a 5 judges bench cannot overrule a 7 judge bench judgment because 5 is lesser than 7. So essentially it either has to be a bigger bench than 7 or 5. So when I asked him what was the composition, he basically said it's a full bench judgment, which means that it's a absolutely good. Proceed.
Certainly, my lords. The second limb of my submission is that the reservation which is made to the president for consideration is subject to the limitations prescribed by Article 200 in itself, my lords. But however, my lords, we should see that the only condition which is provided in the second proviso is that such a bill which is derogates the power of High Court can be reserved for the president, my lords. And that is very distinct from the general power of withholding which is given to the governor, my lords, which is given in the substantive part of Article 200. This distinction is important because the second proviso restricts the governor's powers otherwise, my lords. Accordingly, the governor cannot first exercise the power of withholding the assent, thereafter resort to the reservation as an alternative course. That is for the reservation, my lords. He cannot resort to the reservation as an alternative course. Either he can withhold an assent or he can go for the reservation, my lords. My lords, further, when a reservation is sought on the ground of repugnancy, my lords, the state should identify which law is repugnant to the particular law, my lords. My lords, if my lords are satisfied, I may proceed further, my lords.
Thank you, Counsel.
Certainly, my lords. Wherefore, in the lights of issues raised, arguments advanced, authorities cited, it is most humbly prayed before this honorable court to declare that the governor cannot reserve a bill that is repassed. May I proceed, my lords?
Proceed, Counsel. Sorry.
Repassed and reconsidered for the consideration of president and to prescribe defined reasonable time for the functions of the governor under the constitution Article 200, my lords, and or pass any other orders this honorable court may deem fit in the interest of justice, good conscience, equity, fairness, and for this act the petitioner shall be duty bound and forever praised. Much obliged, my lords. It was an honor arguing before this honorable bench.
Right, quite fun. So this is the petitioners have now completed their argument. Both their counsels came and spoke. There's two things that I would like to point out to you. The first one being, if you noticed when he was saying the prayer, he did not look at the paper at all. He was looking directly at us. The prayer is the most important part of your entire oral submission. And why that is, can anybody guess why it is important? Anyone? No problem. So a prayer is what you're asking the court. So you can argue for how much ever long you want, you can do whatever you want. But what the court does in pursuance of your argument is what you ask for it to do in the prayer. Now you can argue why something is unconstitutional, why some provision should be read a certain way. But your prayer only will say declare that this provision be read a certain way. Declare that this act was unconstitutional. So your prayer is the operative part of, even in real court, your prayer is the operative part of your petition. Even in Moot, it's the operative part. So for your whole team to stand and for the speaker who is reading the prayer to say the prayer without looking at the paper is very crucial. And if you notice one more thing, he said the prayer. He said, declare this, do that, and then finally he said, and or pass any other order or orders as this honorable court deems fit. That is the respect you give to the judges. So you say, this is what I want, and or it's up to your lordship, because you cannot dictate the judges what to do. You can only request and pray before them. That was one thing. The second thing, I don't know if you all noticed, but the researcher here, he wrote a chit and he gave it to the timekeeper and the courtroom manager, and the courtroom manager went and gave it to the speaker. So say, for example, the judge is asking a question and the speaker doesn't know the answer, or there is something the team wants to tell the speaker speaking. They cannot stand up and go tell the speaker like that. They need to write it in a chit. They need to give it to the courtroom master. The courtroom master will give it to the speaker and the speaker can read it and act accordingly. So while a speaker is speaking, you cannot directly get up and communicate to your team. The team will communicate via chits. Okay? We'll proceed.
Yeah, I think that is also something which all of you have to note. If you're all sitting on your seats which are designated for you, you seek the bench's permission before assuming the podium. because you can't storm off as you deem fit, because at that point it actually becomes that judge's code. So you can't go around play and do everything. So you stand up and then you request the bench's permission. The council seeks permission to approach the dais. So that is basically her podium dais or podium house, however it was. And then once we say yes, and then she says much obliged, your lordship, and then she assumes the desk. Proceed, counsel.
Warm greetings to the Honorable Bench. The Council recognizes the presence of the esteemed ladyship. If it is of no inconvenience for your ladyship, the Council seeks permission to collect. Proceed, sir. Much. The Council seeks permission to start. This is the Attorney General of appearing on behalf of the Union of Aryavarta by the means of Article 76 of the Constitution of Aryavarta, along with my learned counsel, the Solicitor General. Just to clarify, does everyone know here who an Attorney General is? Any guesses? I can hear some murmuring. You can just tell it loudly. Sorry? Yes, who said that?
Close. You're close.
What? Ashwati. Anybody else? Okay, so the Attorney General is the highest law officer of the country. So he is the one who appears on behalf of, he defends the government of India or the Union of India for any matter. The next posting after the Attorney General is that of the Solicitor General. Now, I don't know if this is the right question to ask. Does anybody know who the Attorney General of India is at the moment? Trivia question. Vijay? Vijay Narayanan is the Advocate General
Advocate.
of Tamil Nadu. Very good question. What was your name? Paris. Can we give Paris a chocolate for that? That was very good.
And a round of applause.
Of India? Lovely. Why are you so shy about the right hand? Oh, that's right.
Yeah.
The
For the others, it's Shri Venkatramani. It's Mr. Venkatramani. He's basically from the Madras Bar. And then he's gone, to all the way to Supreme Court, and he's been assuming the office for 2 consecutive terms. He's the Attorney General.
The council seeks permission to serve a compendium to the honorable bench and the opposing counsel.
So this again, this is not something which is mandatory as a part of your Fresher'S Moot. But when you go to moot court competitions, this compendium is basically a compilation of judgments you rely upon. We just wanted to show you how does it work. So basically, it will have all the judgments copies you're relying upon so that the judges do not because there is no need for the bench to automatically believe whatever you say is right. There is a fair reason that you might be misrepresenting the ratio as well. So it's always better that whichever, for example, when Francis Corley Mullen was put forth, you all the more have the duty to present the court a copy of the judgment. So all these judgments put together is what makes a compendium. And you have the duty to serve it to the bench and to the opponent counsel. You can't just give it to us and leave the opponent counsel. It's a duty for you to serve both the people. Proceed, counsel.
Your Lordship, there are 2 issues before this honorable court today. I shall address issue number 1, while my learned co-counsel addresses issue number 2. With the issue 1 being whether a writ petition filed by a state government against its constitutional head, that is the governor, seeking constitutional amendments under the Article 32 is maintainable, or whether it is barred by personal immunity granted to the governor under Article 361 of the Constitution. Your Lordships, the councils, is the Lordship clear with the facts? The council would like to put forth arguments in 2 grounds, Your Lordships. The first one being regarding the locus standi. The state here has no locus standi under Article 32, Your Lordships. That is, Your Lordships, if I could direct your attention to Article 32 plus 1 of the Indian Constitution, that is the Constitution of Aryavarta, which essentially guarantees the right to move this honorable court for the enforcement of fundamental rights guaranteed under Part 3 of the Constitution. The difficulty here for the petitioner, the Lordship, is that a state government does not possess fundamental rights in the manner contemplated in the Article 32. Therefore, it cannot invoke Article 32 as a vehicle for enforcing such rights. This particular position is established in the case of State of Rajasthan versus Union of India, 1977, where the judgment of this Honorable Supreme Court made a distinction between the rights of an individual and the power of the state. Here, Your Lordship, this was further established in the case of Krishnan versus Krishnaveni, 1997, where the state stands excluded from the purview of expression, person, for the purposes of fundamental rights. Here, this position has two logical backing, Your Lordships. First one being, fundamental rights operate primarily as a protection against state action. So thus, the state cannot place itself in a position of a right-bearing individual and seek to enforce fundamental rights against its own constitutional framework. And second, Your Lordships, even if there is a grievance, the state shall approach the court through Article 131, which provides a separate mechanism against disputes between union and states or between states, where the dispute involves a legal right. Thus, Your Lordships, the present dispute, therefore, being between the state government and the governor in his constitutional capacity, cannot simply be converted into an Article 32 proceeding. If the lordships are clear, can I move to the next? Your Lordship, now I come to my final ground, the protection granted to the governor under Article 361. The Article 361 clause 1 expressly provides the governor shall not be answerable to any court for the exercise and performance of the powers and duties of his office or of any act done or purporting to be done by him in the exercise of the performance and those powers of duties. Here, Your Lordships, granting or withholding assent under Article 200 is an exercise of the governor's constitutional functions. Therefore, such acts falls within the protection contemplated by Article 361. Here, this was held in the presidential reference of in re assent, withholding or reservation of bills, which is again under Article 143, where this honorable court held that the court cannot fix a timeline for the governor or tell him how to exercise his constitutional discretion. Here,
Counsel, your contention is basically that this court cannot direct the governor by the very provision in the constitution itself.
yes.
Are there any other contentions which you have, counsel? I think we are convinced with your arguments. You can.
Much.
Do you have any other contentions?
I have one other last.
Can you just give us a brief of it?
It is regarding Article 361 clause 4 of the Indian Constitution, which requires 2 months written notice to the governor before a civil proceeding.
Can you read the text of that provision, counsel? Do you have the copy of the constitution? So guys, if you look at the present situation, we asked them for a specific provisions reading. Now, you would have prepared your script using your best methods whatsoever. Ensure that your script has the extracts of the provisions you're all the more quoting. So every time the judge is asking for a specific provisions, exact words, it has to go verbatim as to how it is in the Bare Act. So always carry a copy of the Bare Act of whichever proposition you're arguing. So all the more the co-counsel had, because of which they helped the counsel. So when this applies to your Fresher'S moot as well. If you have the proposition, it shall definitely be on constitutional law. So please take the liberty of buying the constitution's Bare Act. It will be useful for your entire life, from this point. So ensure you bring the book, you bring the Bare Act, and every time it's being asked, present as to what exactly is the exact provision.
If there are any delays with your constitution Bare Act, you can borrow it from the library also temporarily.
Section Article 361 clause 4, which states that no civil proceedings in which relief is claimed against the president or governor of a state shall be instituted during his term of.
Thank you, counsel. Thank you, counsel. We'll let your co-counsel take over.
Please, court. This is the Solicitor General appearing by means of Sub-Rule 5B of the Law Officers Rules of 1987. The counsel seeks permission to proceed with my arguments. Considering the paucity of time, the counsel will keep the arguments very brief. The first sublim addressing a very misleading argument which has been put forth by my opposing counsel with regards to the powers vested under the governor under Article 200. However, the council on behalf of the union would like to put forth that there are not three, but there are four options which is available to the governor. The first one being granting assent to the bill. The second one being reserving it for the consideration of the president. The third one being sending it back to reconsideration to the state assembly. And finally, withholding assent to the bill. This is not a frivolous claim that is being put forth by the Union of Aryavarta, but rather supported by a constitutional bench judgment, which is the state of Bihar versus the Kameshwar Singh judgment. In that specific judgment, they dealt with the Bihar Land Reforms Act. And while dealing with the powers of the governor under Article 200, if I may deal with the exact verbatim paragraph of the judgment as laid out in paragraph 235. Under that article, the governor can do one of three things, namely, he may declare that he assents to it, in which case the bill becomes a law, or he may declare that he withholds assent therefrom, in which case the bill falls through unless the procedure is followed. Therefore, it recognizes the procedure where the bill will fall through where the governor intends to. Because taking jurisprudence from the Valluri Basvaya Chowdhury case, where they recognize the governor as part of the state legislation under Article 168, this power has been granted.
And yeah, now if you look at what Indian did, now he specifically said that this is the proposition. Like, since he is the respondent, he has the duty to respond to what the petitioner has said. Now, for your Fresher'S moot, it will be a solo moot court, it will be a solo moot where you will just walk up and present the contentions as such. But however, when a real life competition is concerned, as a respondent, you always have the duty to respond to the contents of the petitioner, number one. Number two, when he had relied upon a specific a proposition by the petitioner council, which was that Kavin Aldemore said that there are only three options to the governor. And now Indian says there are not three options, there are four options. And I'm not telling, there's a judgment which says so. And then very most precisely, if you had heard, he had set us the paragraph number. Now, at the impression of the bench, it is presumed that he has read the whole judgment. It is a very, it's a very mind tactic you play right there by just telling the paragraph number. For what it's worth, I may ask him the compendium as to give me the exact judgment copy. I'll check the paragraph myself. But the second I hear that specifically paragraph 234, it builds a good impression in my head as to the council is well prepared. So ensure that when you read through paragraphs and you specifically say, and very most importantly, if you had looked at the way he emphasized on the important part, there will be 3 to 4 sentences in that particular paragraph. But it is your duty to enunciate specifically and emphasize as to he enunciated on the part where the bill fails through. So at that part where he would have gotten the bench's attention, where all the other sentences are monotonous and then he stresses on it fails through, the bench automatically hears that word and recognizes that as an option. So you essentially have to know where you have to place emphasis and where you have to play a monotonous, tone. Proceed, counsel.
Certainly, my lords. My lords, now moving to the second limb of my argument, which would deal with the legality of the so-called timelines which the council of the state seeks to enforce in this present matter. Your lordships, it is very pertinent to note that the constitution has certain time limits expressly available in certain provisions, and therefore the express mention of time limits in certain provisions implies their exclusion in others, especially in Article 200 in this present matter. However, I would also like to rely upon the judgment of India versus King Nandan Agarwal, where it held that it is not the duty of the court either to enlarge the scope of the legislation or the intention of the legislature when the language of the provision is plain and unambiguous. But regardless, since there might be a situation where the governor is misusing the words as soon as possible, which was expressly held to be the most appropriate term even by the Constituent Assembly, the council recognizes that there might be certain misuse. But what is the remedy available? However, my lords, it is very pertinent to be noted that in the Padma Sundar Rao versus State of Tamil Nadu judgment, they had held that while interpreting a provision, the court only interprets the law and cannot legislate it. However, if a provision of law is misused and subjected to the abuse of process of law, it is for the legislature to amend, modify, or repeal it if deemed necessary. Therefore, this court does not have the powers as specifically claimed under the separation of powers doctrine to interfere in this present matter, Your Honor. But however, let us say
You said that there is a possibility of misuse. So what is your remedy for that possible misuse?
Certainly, Your Ladyship, as seen in the Punjab cases as well, this court is very well empowered to issue recommendations to the governor in order to sign or give assent to these bills. But however, if we were to enforce such a timeline, there might be certain consequences which would be in blatant violation of the basic structure of the constitution, which the council will be pointing for. Your Lordship, I'll be dealing with Article 142 in my third subject. But regardless, yes, certainly, ma'am. Certainly, my lord. My lord, Article 142 gives this honorable court the power to issue directions or order decrees in order
What
to
did
ensure
142 say?
the exact verbatim direction. Certainly. Section 142 says enforcement of decrees and orders of the Supreme Court and orders as to discovery, etc. The Supreme Court in the exercise of its jurisdiction may pass such decree or make such order as is necessary for doing complete justice in any cause or matter pending before it.
Therefore, we can do anything for complete justice.
Certainly, Your Lordship. But however, the issue here is, even if we take the case of state of Tamil Nadu, River in Tamil Nadu, even in that specific case, in the judgment, it was very explicitly noted that he is deemed to have served the sentence. The court never stepped into the shoes of the executive or the legislature, stating that he has to be given pardon. It never took the certainly not, ma'am.
Doctor said that the Constituent Assembly debate was, they used the word as soon as possible. So how do you interpret as soon as possible to be such long periods of time?
Certainly, Your Lordship. But I think the fundamental understanding of the powers of the governor has.
Counsel, you think? You think?
I don't think so, Vidra. There is a place for your thought.
I don't want to hear your thoughts, Counsel. I want to hear the Solicitor General submission.
Certainly, Your Lordship. Your Lordship, the Article 200, the powers which are granted to the governor under Article 200 has to be read accordance with Article 168. The governor cannot be a mere rubber stamp who just gives assent to the bill on the consideration of the Council of Ministers or the State Assembly. The governor, as part of the state legislature, also has the power to review the merits of the bill, for which he may require certain amounts of time.
Exactly, council. But right after you review the bill, you send it back to the legislature. And now if the legislature sends it back to you, you have no other go than giving assent. That is exactly what the provision reads. You can exercise your application of mind once, and then you can send it back to the legislature. Understand that these people are elected representatives. They are sitting in the legislative assembly debating on the bill. And you think as one person, you will be able to do justice by just exercising your own application of mind over a bill?
Certainly, my lord. But however, here in this present matter, what the council for the state is seeking is for enforcement of judicially binding timelines, which is what the council is contending to be untenable here in this present matter. Because if we were to enforce these timelines, let us say the timelines expire in this present matter, then the court would have to interfere and it would have to review the bills which are contested in that present matter, go into the merits of the bills and see if the time taken by the governor or what the governor seeks to be reasonable is reasonable in that present matter.
Okay, Counsel. So what do you suggest the remedy is for possible misuse?
Your Ladyship, the remedy for the states in this present matter remains the remedy that has been given to the states for all of the in the past judgments as well, in the Punjab case as well, where they can get recommendations to the governor in order to take action on these.
Yes, so there is a judicial intervention in that remedy itself.
Certainly not, certainly, Your Ladyship, but it cannot be used to enforce an absolute binding timelines, which is
Counsel,
for
do
all
you
sorts
not
of bills.
think instead of every time there is a misuse, the judiciary coming into place, today, one day we'll decide what the timeline is so that the governors know that they will be facing judicial review or the judiciary will be entering if they don't finish in that specific timeline. And therefore, everybody will act accordingly. There will, in fact, I don't think it will increase judicial intervention. I think it will decrease it because we'll interfere once and we'll close that matter there.
certainly your leadership, but however, if we were to place such timelines, then it would lead to the extension that if, let's say, what is a reasonable time for taking action on that bill?
We will decide, council. We will decide. I think this court is very well empowered under Article 142 to do complete justice. We'll set that 120 days is the deadline we presume it has to be.
That is exactly the point that the council begs to differ on, my lords, because if the court has to determine what would be a reasonable time for that specific bill, then the court would have to.
Now, guys, if you look at, I think it becomes an argument between the bench and the council. Now, if you had actually looked at, Indian had not been referring. Had not been Number one, you get to know that the bench is hearing your arguments. Number two, you have to be very respectful. And now I said that we'll explain the power under Article 142. We'll lay down the law of the land under Article 141. Let us read it. But now Indian could have said, no, you cannot do that. Or you cannot do that, even in a very modest. But he said that is exactly where the council tends to differ. So to look at how honest it is, I need to talk to another one of it. So the way to go. As what is the responsibility? Not third point. But concept is one thing. I believe that it cannot work. That's where it is on the question. They need a place for your concept or something. And I think for someone, I think that from the
Certainly, my lord. Wherefore, in light of the issues raised, arguments advanced, and authorities cited, it is most humbly prayed before this honorable court to dismiss the petition, to dismiss the present petition in its entirety, and or pass any other order that this court may deem fit in the light of justice, equity, and good conscience. And for such act of kindness, the counsel for the respondent shall be duty bound and shall forever pray. It was an honor arguing before this honorable court.
And now, as I told you earlier, two important disclaimers again. This has nothing to deal with your Fresher'S proposition. The governor's rule was just picked as a proposition. This is exactly what they were working during their Fresher'S. But for this year, Mariam has come up with a very good proposition, which will be released by tomorrow. So all of you will take the liberty to read that proposition. It has nothing to deal with the governor's post at all. Please take the liberty of reading the proposition, number one. Number two, unlike how you see teams of three, your Fresher'S competition is a mono advocacy competition, whereby it will be just you who will function as the speaker and as the researcher. So please understand that you will not have a researcher to aid you, pass you chits, have books. You have to come 100% prepared all by yourself. So ensure that you're taking it that way as well. If you have any doubts on the mock vote, we'll be more than happy to address. If not, we proceed to the next session. Good. Okay, another concept which you have right here, thank you so much for pointing it in. There's something called rebuttals. So, what basically are these rebuttals is right after respondent completes the arguments, the petitioners have the right to rebut. I want you to pay attention here. It's right to rebut because these people have put their case. These people have responded to it, and most of respondent submissions are basically the counters of what the petitioners say. So the petitioner has the duty to again put forth this case, but not for anything more than 2 minutes, or basically how the rule book is framed. Now, all the more, the rebuttals have to be confined to whatever were the submissions by the respondents. You can't raise additional grounds in rebuttals. You cannot argue more points. The time for rebuttal is exclusively given for you to rebut. Rebut is basically அவங்க சொன்னதுக்கு நீங்க திருப்பி you're giving them an answer. As to the learned respondent counsel said this. However, the petitioner counsel, if I may please differ with my friend on that. And then you say what is your contention. And if possible, if the rules provide for it, surrebuttal will be granted. Surrebuttal is where these people again get an opportunity to respond, and that is where things officially end. There is no more anything. Adukapparama the scoring part fully takes over. Good. So you have petitioner's arguments, respondent's arguments, rebuttal, surrebuttal if it is provided for, and then the scoring part begins. All of you can happily go, or if not enough, you have the next session. Thank you.
Thank you, second year representatives and our judging panel, for a wonderful showcase of a moot court competition.
The journey through law school extends well beyond the four walls of a classroom. Moving forward, it is time to learn about the backbone behind this very orientation and all our mooting initiatives, the Moot Court Association itself. To give us an overview of the MCA, its vision, and the abundant opportunities that lie beyond the classroom, we have with us Mr. Ashwit Dinakaran, the president of the Moot Court Association. May we invite you to address the gathering?
Thank you. Thank you, Tejasvi. Yeah, I think all of us have considerably taken your breaks, which is definitely acknowledged. We'll definitely let you at 1:30 for lunch directly. I mean, there's nothing I can do at this point. From 1:30 to 2, you will have your break definitely. So I'll rest assured, I'll definitely ensure that all of you leave before, leave right after 1:30. So so basically, I'm Ashwat Dinakaran, the president of this year's Moot Court Association, and I'll be briefing you as to what is the MCA, what do we do, and how do we take things forward? What are the benefits of being MCA? Because I think Mariam has very, very beautifully dealt with what basically mooting is. Now, and an additional factor, the last slide where she said, and the excellent benefit which comes out of mooting, if you keep doing it consistently, is that you get to be a part of us. So by us, all the more, and there are multiple, reasons. I think we have a presentation made. We just on our way to put that on screen. I think we'll take it right from there. But as of the Moot Court Association is concerned, Moot Court Association of the School of Excellence in Law is the oldest association, oldest student-led association in the university. It was established in 2008 by our founding members, and it is to be noted that in presently, I think all of you might have attended the previous day's orientations, like for example, ISUD and ROTRAT and everything. Most of these orientations, if you are taken into account, were happening at 2 p.m. I think this association alone was granted 10 a.m. slot. Why do you think why do you think the dean and basically the advisory committee of the MCA thought that this should happen from 10 to 1:30? Why is attendance being granted for these 4 sessions? Not because MCA, not because of MCA, because mooting is a core paper in your final year. Mooting is basically a paper where you will be granted 100 marks, which will be going on your statement of final grades. If you do not pass your clinical paper for mooting, you will not basically receive your degree. Mooting is a part of your curriculum. And all the more, when the Board of Studies had drafted the curriculum, we came up with the notion that, the Board of Studies came up with the notion that mooting has to be a part of the entire law student curriculum itself, because it basically gives you the confidence and the preparation as to how does a court basically work. And to understand that, to take all operations of Moot Court, in 2008, the Moot Court Association was established. Subsequent to that, now you have a great deal of committees, but considering this is a part of the curriculum itself and the association is of pivotal importance, we ended up giving, the management was gracious enough to give the morning slot itself. And now if you look at, this is basically the Moot Court Association. Can we please go to the next slide, Bhuvanesh? So what are we going to cover? I think maybe it's better if we zoom in a little. So we'll be dealing with who we are and what we basically host and how we host them. And then you have, how you get on a team and what the students have brought home. I think Mariam has already dealt with that. I'm not going to go there. And how do you join the association? Next slide, please. So these are basically what I'll be covering in the session. I think I can keep it in 10 minutes considering we are in positive time already. So as I've said, this is the oldest student, this inherently functions as a student bar. We have been responsible for creating indirect placement opportunities. And now, the university is very grateful that we have a separate placement cell working on it. But right from 2008, we have created inherent placements. How do we do it? By the moots we organize. So I think most of you might have understood that all of you, after you graduate, will have your name and your degree behind. But how do you think you're going to get employed? Of course, all of you would have to make your CVs. And it can't just have your name and your degree. Because mooting, if it becomes a part of your curriculum, it becomes a clinical paper. Thereby, it's mandated. You have to do it. But how do you take an extra step? Where do you take, where do you take an extra step and contribute to your basic resume whatsoever? Now, this is exactly where you have to participate in external moot court competitions conducted by other universities and other institutions. And that is exactly what, we'll be taking on progress as well. So, the moots which we do basically are two flagship national moots. The first moot is called the Pro Bono Enviro National Moot Court Competition, which is one of the oldest moot court competitions which, India has ever had. And this is the only oldest moot court competition exclusively dedicated for environmental law. And I'm very happy to let you all know that this year we'll be hosting a commemorative edition of 20th Pro Bono Enviro National Moot Court Competition. This will be our 20 years of conducting Pro Bono. That is one flagship national moot. The second event which we conduct is the K.R. Ramamani National Taxation Moot Court Competition, which is also more than a decade old, more than a decade and a half old. So we are presently this year will be the 17th edition. This is exclusively dedicated for taxation. So these are the two modes which these are basically conducted all under the aegis of the School of Excellence in Law, especially by the Moot Court Association. And then we were also vested with the responsibility of conducting the Surana and Surana National Trial Advocacy Competition, which I believe most of you might have, had a little heads up about, because most of the witnesses are from first year, I believe. To the people who have signed up, excellent job on that, good initiative. Please keep up the spirits. So this trial advocacy arises out of the Memorandum of Understanding, which is between School of Excellence in Law and the Surana and Surana International Attorneys, which is a law firm. So we are conducting their South rounds for trial advocacy competition, which is also something which we do. So we have three, apart from which there is something called the Tamil National Trial Advocacy Competition. Tamil National Trial Advocacy will absolutely go fully in Tamil, where we conduct trials. And this as a part of our us being the state university, we are bound to conduct one competition fully in Tamil, where all government law colleges of Tamil Nadu plus Symbiosis and other big colleges come and contest the full trial in Tamil. So, you will get to hear words like Metta Panigire Needi Arasare, which basically means much oblige your lordship. Interesting part. I was fascinated when I heard it. So, as how we say in English, we go on to say much oblige your lordship. But then when it comes to Tamil trial, you say Metta Panigire Needi Arasare. So, that Metta Panigire is basically much oblige. So, we'll definitely invite spectators for the finals of trial advocacy. It will be great if all of you could sign up, and there will be a lot of words which you'll all the more be discovering on that. And apart from that, our intra-university events include one, the Fresher'S Moot Court competition, which we conduct, and we call it the Ab Initio 2026. Is there any person who knows what Ab Initio is? Good. I think I have one, person who's answered. Can you just put your hands up? Don't worry, I'm not going to ask you. It'll be great if anybody can. What language is this? Latin? Good guess. It's Latin. And there are a lot of legal maxims for people those who are prepared for CLAT or Kunjo did their homeworks at the back or studied legal studies in a 12th standard. There are a lot of Latin terms, which we inherently use as a part, because Latin was basically very connected to law from the earlier, because that led to the origins of law in itself. So there are a lot of Latin maxims which we end up using, and ab initio basically means from the beginning. So from the beginning is what we say all the more. So since all of you are at your very beginning, we call it the Ab Initio 2026. And for another thing which we conduct is basically the 3-year LLB Freshers Moot Court competition, which we call as de novo. So de novo basically means to start again. Since they have already completed the degree and they're coming back to start a degree again, we call it the de novo, the de novo 2026. So these are the two competitions, apart from which we conduct one basic, very big law fest called the Intra-University Law Fest, where all of these people, which is not just the freshers, all the 5 years of batches of law school all come together to participate in a multiple range of competitions which we host. For example, we conduct an ADR, we conduct trial advocacy, we conduct Tamil moot, we conduct English moot, and there is judgment writing, so much all like that. All of you will have an opportunity by that time, if you participate in your freshers, to participate in RE as well. And that is something which we do. So there are basically 7 competitions. Yeah, I think this slide is already dealt with. We've been there since 2008. Yeah. Can you go to the next slide? Yeah. So this year, I mean, it is. So this is basically proposed as to a tagline which we have invented this year, which is the first word is argumentio, which is we like as to the argumentio is basically which means reason debate, and this is referring to the part where we host. So these three words altogether define what MCA does. So argumentio is basically where we host the moods, national, state, and intramural, where reasoning is tested against the hardest problems in law, and then you have advocatio, where we select and train send teams that carry the colors of School of Excellence in Law. If anything, I think a great deal of the mooters who have been in Moot Court Association, we can all guarantee, if all of you have the time, I mean, of course, we'll be taking you through the website. The Moot Court Association website, if you go to the previous office bearers list, you'd be able to find almost some 19 years of previous leaderships where we have had different presidents, vice presidents, and general secretaries of MCF who have gone on to rule not just the Madras bar, but even the New York and California bars. All of these people, those who have assumed, like, the important positions of MCA or even been, like, any of a member in MCA, all of these people are basically very convicted. One thing you have to understand is that the association's membership, which is for MCA's membership, which is concerned, is based on nothing but your voting experience. So if anybody wants to assume the presidency or the general secretary seat or any of the core positions, you have to decide right from your first day, because the competition is getting heavy year by year, and the more and more you keep voting, the more and more we give you points, and the points is the exact basis on which we let you assume these important positions. So all of the people those who have assumed these seats are absolutely convicted. So that conviction is what MCA gives you. If voting gives you confidence to join into MCA, you definitely need that conviction, which is exactly what is another benefit. And you definitely have equitas, which is fairness and equity. We keep every process open and every election transparent so that everybody has the right opportunity. So all the internal challenger which we conduct, oh yeah, there's another task which I wanted to give you all. Yeah, never mind. I'll just tell you. So there's something called the forbidden game. So I'm gonna give you two words basically, and I mean, let's keep it yeah. There are two words basically. One word is MCA, other one is IC. IC, and the other one is MCA. Every time I say MCA or IC, I want you to mark a tally in your notebook. All of you have studied tally marks, no? Like 1 and then 4 and then a slash. So, and we have we have two people from the MCA who's calculating the actual number, and say if that number matches with your number, there'll be a treat. Yeah. So this way, I mean, trust me, this is not my idea. I was asking ChatGPT as to what ideas, how do I make my people so attentive? And then it said, go the forbidden game rule. It'll make sure that everybody pays attention to whatever you're saying. It starts right from now. MCA. I said it once, so there should already be a strike in your notebook. Oh yeah, so yeah, that's basically Equitas, where every process which the MCA conducts is basically, I'm not stressing anymore. All of you get it right from there. Yeah. So where every process which we conduct is basically transparent. Next slide, please. Next slide. So what we host next, yeah, I think most of this is already covered. So yeah, the pro bono, KRR, and Surana trial, national trial, ab initio, de novo, intra-university law fest. Two of these are yours this year. And especially for the 5th years, I think I'm certain that ab initio is all the more yours. And this, yeah, I think we can go to the next slide as well. We'll run. So pro bono, I told you this is the environmental law, and this year we'll be having our 20th edition. And multiple national law universities and Symbiosis, General, all premier law universities have been a part of this competition. And as I've already told you, we are the only we're the oldest national moot exclusively dedicated for environmental law. So most of the institutions, if you taken them into account, they would have started their moot court competitions in some 2015 or 16, making them 8th or 9th editions. But the vision was too early by MCA members earlier, because the quality School of Excellence in Law was so good that they wanted to start a moot court right away. Because of it, in 2008 itself, we had instituted the Pro Bono Enviro National Moot Court competition. And yeah, we are in our 20th year this year. Next, you have the KR Ramamani National Moot Court competition. This is in collaboration with SAPR Advocates, so which is headed by Mr. Vikram Vijay Raghavan, who's also an advocate who exclusively practices stats. So MCA conducts these two exclusive events where we have picked very niche propositions of law. Most of the institutions which have picked their propositions is basically constitutional law, or they just call themselves a national moot court competition, but there is not a specific subject. But however, the competition which MCA has been doing for the past 2 years are absolutely the niche subjects which are, basically environmental on tap. So next slide, please. Surana and Surana has already dealt with. This year, we are dealing only with South. I mean, this year and the previous year, we've been dealing with the South regions where we've been hosting teams and conducting trial advocacy next. Tamil advocacy already dealt with. ITRA University Law Fest done. It's basically a 2-day festival. Yeah, and you have your ab initio, which is this slide is very important for you. This is the most relevant stuff for all of you. Yeah, and there is a rough deadline given for you. Yeah. So we did a circle. I don't know if the circular was circulated to all of your WhatsApp groups. We did a circular 3103 by the Dean's office. The ab initio, the Freshers Moot Court competition is made mandatory for all of the participants. So thereby, all of you are humbly requested to accede to the request and ensure that all of your registrants are basically recorded. We'll be opening the registrations from tomorrow. The next session basically is where I'll tell you how do you register for the moot. And then on a real-time basis, we allot the moot. I think we'll come to the this later. On 15th September, you have to ensure that your memorials are being submitted. So right after you complete your registration, your mentors will get allotted on a real-time basis. So right when you click the submit form, you will be allotted a registrant ID and your mentor will be allotted right there. They will be given 2 WhatsApp links. I want all of you to pay attention because this is not something which your mentor will be aware of. This is your route to get to the mentor. But this is not something which you will be able to reach us anytime sooner. And most of the times you might have to reach us through our members and it'll be hard. So it's ideal that all of you pay attention, especially the boys at the back. I hope I have your attention. Yeah, thank you. So registrations open by tomorrow. We'll be coming to your classes respectively and asking you to register. However, we'll brief you as to how do you register right away. And then of course on a date basis allotted, you can all of you will have a mandatory meeting with your mentors where most of these mentors basically are 3rd years, 4th years and 5th years moots. So we have handpicked these people and we'll put you in touch with all these people. So it'll be easy for you. Any of the doubts you have as to it can be as lame as possible. I think, fortunately, all of you have ChatGPT because of ChatGPT or Claude. I don't know what you're using. Most of you will be able to get your doubts cleared, but it's always ideal to run everything through your mentor because ChatGPT or Claude has not appeared before benches. It does not know courtroom language. Maybe it does a little, but anything which you confirm, if it's lame, go ahead and ask your AI. But either way, take the liberty of consulting your mentors basically. Followed by which, 15th September shall be the last date for submission of memorial with no penalty. However, from 16th to 18th, you will be able to submit your memorial, but you will be incurring a penalty for a day. So it will be -2 marks for every memorial concern. And then you have on 21st and 22nd of September, the oral round happen. Both these days, we'll be specifically telling you on which day you have to come. Ensure that you're mandatorily present on that day. The other day, you might have to attend your classes for which attendance will be recorded. As of MCA's records are concerned, for the day you make oral rounds, that day's attendance will be granted from our side. So ensure that all of you are mandatorily present for the oral rounds. Please remember that if you do not submit your memorial, you will not be eligible to participate in the oral rounds. We're making it very clear. Please, all of you will mandatorily register. All of you have 20-day window period to prepare your memorial. Ensure that your memorials are prepared. Your mentors have a review and then you submit. Based on which we'll send you a confirmation email telling that a memorial is acknowledged. Prepare for your oral rounds again with the assistance of your mentors and then ensure you appear for the oral rounds. You have to mandatorily be present for the oral rounds and the memorial also has to be submitted. And on 25th of September, we'll declare the results. Next slide, please. Yeah, Dino was something which we conducted for 3-year LLB. I think we can go to the next slide. Yeah, how we host the moot next. Yeah. So basically, when it comes to hosting moot, I told you about pro bono and taxation moot court competition. How do we host the moot? Basically, is one, we draft the proposition which teams will be arguing. Second, I'll keep it as simple as possible because it's something MCAs people should be knowing. But just to give you all a little heads up as to what we do, we publish the rule book, we open registrations, we make calls to multiple universities across, we send them emails. based on which, because for them, both of these moots are absolutely considered to be prestigious. So they end up they wait for the invitations to come. The second invitations come, colleges rush to make their registrations. And once we open registration, they complete the registrations. We then receive the memorials, and then we convene the bench. Convene the bench is basically arrange, call judges. So one thing which I wanted all of you to, which I wanted all of you to know is that when I was telling you that MCA was inherently functioning as the placement, as the placement committee, what did I actually mean by that? So for the past 19 years of MCA, we have invited real-time advocates, senior advocates and judges to this campus. The same state which you're seeing has seen multiple judges of the Supreme Court, High Court, and many senior advocates, all invited via MCA. And if you're an MCA, you get an opportunity to interact with all these people. Now, interaction could be as minimalistic as it is for you, as as the word might not seem intense. But at some point, if you ever see the judge again, and the judge fairly even remembers you, that is all that matters. Because networking is the most important thing about our profession. When it comes to moots, there are almost 18 to 20 teams which basically come inside, this Taramani campus. And all of these people, if you're the usher allotted to that particular team, every team will have a team buddy. So that team, this team buddy will be allotted, which will mostly be first years and second years. So if you're inducted into MCA, you get to interact a little too closely with the teams. So for example, very recent, something which happened the last week, I went to the Astria Moot, which happened in Pune. That was one of my first year moots, whereby I had this interaction with Ms. Radhika Shinde, and she was in her third year. Both of us were we were talking very good. She was asking how does the Madras bar function and everything. She enrolled in the bar earlier. A week ago, she reached out to me asking if I had enrolled in the bar, and there was a CRP which she wanted me to do in Karnataka, in Bangalore. So you never know where cases come from, because the fact that she lives in Pune, most of you are in the cyber world. And for cyber matters which are concerned, cyber complaints can come out of anywhere. And you will not be aware of the people, those who might be where your attackers basically are. But you might have to travel all the way where the police station is. So at places like this, MCA comes in handy. Since you have interacted with these people, now there is a potential clientele for you. So this networking is exactly what MCA gives you. And the interactive opportunities, there are a lot of people all of these people, the judges those have come, judges we have liaison officers appointed. So this person always stays with the judge, ensures they are absolutely hospitable and everything, based on which they are fully accommodated. So all on that is also there. So on a later part, if you run into them in courts during your internships, you can all the more give them a good evening, and then they'll make this face, oh, I've seen you, sir, I had the pleasure of hosting you for the pro bono, but oh yeah, how are you doing? That becomes a conversation. So ensure that all of these networking opportunities cannot happen in random. If you do not really have such opportunities at all, you can't just walk up to a senior advocate randomly and expect him to address you. That's not going to happen. But MCA becomes the platform through which you'd be able to address or interact with these people. So that's basically us. So that comes as a part of the convene the bench, run the rounds, and we declare the results. Next, Bhuvanesh, next slide. How you get on a team. So this is basically where we talk about your IC next. So this is something which I want all of you to pay attention for, because right from after you complete your freshers, if you complete your freshers and after you complete your freshers, based on the mooter ID which you get only, your eligibility to participate in any moots for the next 2 academic years are concerned. Basically, if you do not participate in your freshers moot, you'll be barred from mooting for 2 years straight. So ensure that you're participating. This is a way enforced, because without freshers experience, we cannot trust you to represent the institution. At the end of the day, you represent School of Excellence in Law, and some experience has to be already fed to you, because this institution has been of great standards. So all the more to ensure that the standards are always kept, we funded something called Internal Challenger, IC. So IC basically is where we go on to. So internal challenger, as ipso facto, it speaks for itself. Where all the teams which are interested to participate in a competition contest one among each other, and we pick the best. We pick the best among them. So can we go to the previous slide itself? So the invitation arrives. The other external institution sends us the invitation, and then we we do a PR, and it is notified on our website. I'll show you the website. And next we have the IC registration. It opens. Registrations close for that time. You have to register within that time period. Team codes are allotted. That is also on a real-time basis. We are doing it. And the group is created. A WhatsApp group will be created with all your respective participants. The IC judge, which is mostly a passed out or someone who's been in MCA, who's presently practicing, will be called to judge the IC. Once that is done, internal challenger is complete, and then you get to register, travel, and compete. Next slide, please. Yeah, I told you what IC basically is. So this is where we conduct the competition. Next slide. Yeah, so mcasoil.wordpress.com is basically our website. You can take a picture of the site, you can take a picture of this mcasoil.wordpress.com. We are presently working on our own domain, so I think you will have a, you'll have a new website later. But for now, this is the website we've been presently, using. So this is exactly where we will notify all the moot court competitions to which invitations are received for. So all our IC invitations are basically put here. Please ensure that all of you at least keep a track of the website weekly once to check which moots are being hosted. It's mcasoil.wordpress.com. Next. Yeah, I think Mariam has already dealt with this. So all of these are our achievers. We just skip this full part. Next. So all of these people who you see were our previous office bearers. I can give you names like Ms. Niremati Nagarajan, who's enrolled in the who's enrolled in the New York bar. She's an advocate at the New York bar. Mr. Manjunath, Ms. Bhagavati Venimale. All of these are our previous presidents and general secretaries who have occupied. And all these people are basically ruling the bar. And now the important part, joining the association next. Yeah, now the association basically is constituted with the following, where as of your, we'll skip all this. All you have to know right now is that all of you, the winners of Freshers, please hear me out right here. The winners of Freshers Moot Court Competition, AB Initio 2026, we'll pick the top 3 rankers. How is this calculated? Your memorial score plus your oral score together will be combined. Per your department, they'll be arranged in descending order. We'll pick the top 3 ranks and we'll induct them into MCA. For first years, the induction is absolutely based on merit. So you have to put in a considerable amount of efforts if you are intended to get into MCA. And subsequently, second year, you will have a member. Third year, you get to be a joint secretary of the highest points among all 4 departments. Fourth year, VP if you're the highest, and joint secretaries if you're following. President if you have the highest amount of points in all 4 departments combined together, and additional secretaries. Next. I think we can skip this for now. Next. Yeah, so you're not really eligible at this point yet. So all of you can all the more note that AB 2026 should be your absolute focus. So focus on the Freshers Moot and we can take it right from there. Yeah, I think we can. Yeah, another thing which I want, which I want all of you to note is that if the website is not accessible for you, most of our achievements and everything is put on our Instagram handle. It's better if you all type it out right away. I know all of you have your access to your mobile phones. It's great if you follow us on Instagram. You'll be able to follow us. And please note the Instagram account is also some 7 or 8 years old. So ideally, I'm not really talking about any other associations. The 3,900 followers which you see in Instagram are basically mostly students of Soel, and 10% it's the other institutions which follow us to ensure that we notify moots and we call invitations. If all of you can follow our Instagram handle in which is Moot Court Association.soel in Instagram, I think it'll be great. All of you can do it right now, or you can just do it at Aram se, considering you're out of time already. Next slide, please. Yeah. All the more you just have to be focusing on ab initio right now. Now I'll tell you how does the site look like. Can we just go to the. So as I've told you, mcasoil.wordpress.com is where you will be finding most of our moots. And as of that is concerned, you just have to type the whole site address in your in your browser. It opens, and at the Kamala you have something called Moot notifications. All of you please take a note of it. On the MCA website, on the tab, you will be able to find something called Moot notifications, which is where your Freshers Moot or the full documents and everything will be will be uploaded. So please know that that is where you will be all the more able to find the whole registration link and everything. Okay, guys, another thing which I wanted to so this invite is basically shared to all of your WhatsApp groups. Am I right? Are all of you able to see the invitation for the Freshers orientation? Very good. Now scroll down. you have this QR right here, which is ab initio registration. This is exactly the QR, not right now. Let's not scan it right now. This ab initio, the registrations are presently closed. We will be opening it only by tomorrow. This is the QR which all of you have to be scanning for your registrations right from tomorrow. So if you scan this QR, it will lead you to just give us exactly 3 minutes. I'll just brief how does the registration basically work. Who is that? So this particular Freshers Moot registration portal is exclusively designed by MCA for you to register for your Freshers Moot Court competition. So as presently, it will say the registrations are not open. I'm just opening it right now to make a trial entry. All of you are requested not to make it. Just a second. So once the registrations open by tomorrow, we'll have our class representatives, we'll have our member representatives coming to your classes asking you to register. Then you will be all the more asked to scan the QR basically. And that is exactly where once you scan the QR, it will open to this in specific. Now here, yeah, please refresh the page forward. So once the registrations open for tomorrow, you will be finding this as this screen where the registrations will open, and on the top you will have time to close. Can you please zoom in a little so people will be able to see? Yeah. So scroll down. Scroll. You have competition materials. If you click, let's not click. The moot position, if you click on there, it will lead you to the moot proposition, rule book, and the Fresher's handbook. Please pay attention to this. The Fresher's handbook is your absolute Gita, Quran, Bible, whatsoever, until ab initio is over. Fresher's handbook literally tells you everything. Everything as to how you have to present your oral arguments, how you have to present your memorials. The 3-hour orientation which you attended today is all put into a 17-page document for all of you to recollect wherever you had stopped from. So if your mentor is not responding, if they, because all of them have their own, all of them, they might be in internships and everything. So if there's a basic, any doubt, please read the Fresher's handbook. Proposition is there, rule book is there, and below you have the registrations and everything. Scroll to the end. And you have basically all the rules. Scroll down, and then you click on the toggle, and then you go to proceed to registration. Can we have one student from here to give their sample details to, yeah. Or do you mind giving yours? Just your application number if you remember. Yeah, so the application number is basically your Freshers, with the allotment ID, which is given. So that allotment ID has to be typed right there. And in full name, you'll be typing up your. So we'll just show you how one basic registration works. So it works is a little too easier for you tomorrow. We don't want to hold back people, if you guys have your lunch, all of you can actually the people also who want to understand the process can stay, because I think you have your orientation for NSS at 2 as well. We don't want to hold you back. So if you want to understand the process, you can stay. Not people are at liberty to leave as well. But yeah, so her details are being filled right there. Yeah, that's that. Yeah, and then you select your course. And then there comes her section, her mobile number, type something in random. Yeah. It has to be a 10-digit number. If not, it will all the more refuse. Is your WhatsApp number the same as your mobile number? This is asked for you to be joining in the Freshers Mentor group. So ensure that you give the right WhatsApp number. Email address. Please pay attention to this. Very important. it has to be as exactly as like, the ID which you use. Please do not give us a dormant ID. Please do not give us an ID where your 15 GB is already exhausted, you receive no emails. Your e-certificates of participation through which you will be able to claim your attendance and prove to the circular that you have attended Fresher'S Moot will all be sent to this email ID, and all subsequent communications as well. For a memorial submission, registration, like, allotment ID, everything will be sent to this email address. So ensure you put it right there, and both of these have to match. You cannot copy paste the first option in the above. That is also restricted. Once that is done, now you can next review my details. Please check this once, twice, once not like twice, but thrice. Ensure that all your information is right. Ensure it tells the department which you're in, the section you're in, because based on a department's only your motor ID gets allotted. If your motor ID goes wrong, you'll all the more be disqualified, because we cannot allot another motor ID, because this is done by the by the system which is at the behind. It's not us. So ensure that you review the details rightly and click on confirm and submit. Now, once that is done, as soon as this screen pops up, take a screenshot. As soon as this screen pops up, take a screenshot, because this is the only way you will be able to remember your motor ID. Your motor ID is very, very important. So once this motor ID is allotted, the 26 stands for the year. HD is a department, like, D is for computer science. 001 because she is the first registrant. P is for petitioner. So she'll be arguing for petitioner in the Fresher'S mode. So your site is allotted. Scroll down. And then I've just, is a sample entry. The mentor, I'll be your mentor. My mobile number is also given. And then the instructions niche are very, very important. So number one, you take a screenshot to note your motor ID. After that is done, scroll down. There are two links basically. After you take your screenshot, join the All Freshers WhatsApp group. This is where all intimation regarding results, all updates will be made. Prior to that, our Instagram page will always be given priority. So stories will all the more be posted there. So first you'll have to click our All Freshers WhatsApp group, join that. Number two is your mentor group. So this is the exact WhatsApp mentor group where your mentor is already waiting for you to join in. So mentors have already been added in the WhatsApp group. So click on both these WhatsApp links. So you're able to join the All Freshers WhatsApp group and the mentor WhatsApp group. And once everything is done, you're all set to go. Your registration is all the more complete. Now, as soon as this is over, your mentor interaction happens, your memorials get ready for the next 20 years, you have your meeting and everything. Next, you have, the last thing which we want to show you is the memorial submissions portal. So the memorial submissions portal is basically through which you will be able to submit your memos. So this memo submissions portal is basically after you design your memos before 15th of September. So where to be able to find the memorial submission is where we will go to our rule book, scroll down. Scroll. It's on the top, I guess. It's in the first 3 pages. Yeah. So in our rule book, under column 4, you will have the link to memorial submission. So that submission, you have to click here. It will be open from the 8th of September, and your final date of submission without penalty is 15th of September. So if you click on that, it will take you to your memorial submission portal, where all the more the registrant ID which you had gotten, is exactly to be typed out here. So if you pick your registrant ID, I remember the ID, 26 HD 001P. HD 001P. Now, as soon as you click on fetch your details, it will fetch your exact details. Verify if it's your name. If it's not your name, it means that you've entered a wrong registrant ID, and that person will be evaluated. So ensure that you give the right ID. And once you click on that, you click on yes, continue. And then you upload your PDF memorial copy and your document memorial copy. And once that is done, you click on submit my memorial. The memorial has to be mandatorily within 2 MB for each file, because we don't have that big of a storage capacity as well. So mostly it will be under 1 MB. So ensure that's there. So once that's done, you click on submit memorial. Most of you will get an email telling that your memorial has been recorded. So all the more you can have that as proof. And then oral rounds will happen. All the other instructions will be given from people on the later part. All clear? Any doubts? If you have any doubts, this is the only platform for you to ask, or else I think we are good to go. All people, the people those whose attendance have not been recorded, please take a moment after, we all disperse you to come to the front, record the attendance, and then leave. I think it's just, I think it's just the latitude which seems to be a problem. If you're, yeah, I think, if you're good, I think we're good to go. All good? Yeah, just give us 2 minutes. We have, a small vote of thanks prepared for you. Okay, okay, okay. Thank you so much. I'll tell you.
Thank you. Yes. Thank you. Uh, Guys, where are the 30 words and the meanings? Nobody got 30 words? Okay. You guys are supposed to tell me when you guys got them, but I was waiting all this while in one. Yeah, whoever, just raise your hand and maybe give your, can we have chocolates being given to them? Yeah. Uh,
The people, those who have not marked their attendance in our portal, please step to the front, scan the QR, and then leave. You will not be given attendance, nor you will be able to participate in the Fresher'S Moot. Water. I want water. Okay. Now, what I can do for you is probably let you record from one of our devices. Bhuvnesh, can you use your QR to record her attendance? She does not have her phone up here. Oh, the geographical location was not. Pavitrin, put the QR up. The attendance का QR.
One second. Tell your name again. Name. Entry. First. That's a deep five to six, right? 3 4 3 9. It says already recorded. The fun already did already. Oh, will be recorded.
Basically, when coming to orientation, I'm leaving the option which can record the article.
Twice you have to record.
Yes.
But
So-
when you're doing it the second time, it's saying already recorded.
Yes.
Anyone else? Yes.
Kumar.
Mail.
Adina, Divas Kumar. 2206. The account have to be even better. SCO 526 508
I think the mail.
It's not able to record your attendance here. Take a picture of this number.
His location is not showing.
Now, just do something. In the picture, in the number photo, I'll create the details with WhatsApp message. We'll add it manually.
The number is not working.